12:34, the Subcommittee on Criminal Procedure will come to order. The clerk will call the roll.
Chair Bojani,
Here.
Representative Cook,
Here.
Representative Bowers.
Here, present.
Right, the quorum is present. I just want to start off by saying thank you to Chair Moody for forming this subcommittee and trusting me to lead alongside these incredible members, Representative Retta Bowers and Representative David Cook. I know we all want to do what's best for the state of Texas, and so I look forward to working together to move this great state forward. I wanted to see if y'all wanted to just mention something, say a few words.
Thank you, Chairman. I just want to say that we do all want to serve and make sure we do what's right for all Texans, but we are glad to serve under your leadership on this committee.
I'll echo that.
Right. As a reminder, anyone present wishing to testify before the committee, please register at the kiosks located in the hallway behind the hearing rooms. If you require assistance in registering or testifying, please contact the committee staff. And to accommodate all who wish to testify today, there will be a time limit of 3 minutes per witness during the public testimony period. The chair lays out HB 467 and recognizes Speaker Craddock to explain the bill.
Thank you very much, Mr. Chairman, members of the committee. My bill passed 2 years ago, and it came out of this committee, actually. We looked at it, it passed the House, went to the Senate, and we added it to another bill when it passed. And then, but all those bills got messed up at the end. It didn't come out, so we're back with it. Ann Johnson's not here, but she's on this bill with me. Actually, 2 years ago, if we were looking at it, Ann said, "Do you understand all this, Tom?" I said, "Well, not that well." She took it over and did it all. So anyway, we're bad. Thank you for having this. House Bill 467 is real simple. It extends the statute of limitations for aggravated assault from 2 years to 5. And your first thoughts are, well, should we be doing this? And we worked with the DA's Association. My DA from Midland is here. She's one of the people that started to work with it. And she's going to testify in a minute. But this gives the victims and the police adequate time to identify the aggressor and present the case to a jury of their peers. And like I said, I've worked with the DA's Association, members of both parties. No, this isn't a political deal. And constituents that are working, that have been working on the legislation. I think this is a good piece of legislation. It gives, like I said, it gives victims the time to process their own crime needs while identifying the criminal, protects all Texans for a longer period from 2 to 5 years, and does not change the legal standard in the criminal code for the act of knowing, intentional, or reckless. So that's basically all it does. Like I said, it passed last session. In fact, I think it passed unanimously out of this committee last session after Ann worked on it. And so I don't even know if she's still on this committee. Not on the subcommittee. Okay. I didn't know. David, were you on it last time? Yeah, I think so. But anyway, that's basically it. I'll be glad to answer any questions. My DA's here, representing our DA, but the other DAs across the state. I think she's talked to some of them in different areas of the state. And I think it's something that we need to do.
Thank you, Speaker Craddock. Really appreciate it. Members, do we have any questions for Speaker Craddock?
I'd like the right to close, Mr. Chairman.
Thank you very much.
Thank you.
If there are no further questions, we'll proceed to testimony. The chair calls Laura Nodolf. Nodolf, yeah. Thank you. Thank you.
It's a tricky name.
It's true. Thank you, Chairman and members of the committee. My name is Laura Nodolf. I'm the Midland County District Attorney, and I'm here testifying on behalf of the bill, for the bill.
For the bill, okay.
So currently, right now, the statute of limitations under...
Sorry, excuse me. Are you for the bill?
For the bill, sorry. For the bill, yes. Currently, under the Texas Code of Criminal Procedure 12.02, the statute of limitations for all Class A and B misdemeanors is 2 years. Under Article 12.03 of the Texas Code of Criminal Procedure, that is the section that deals with aggravated offenses. And it states that an aggravated offense shall carry the same limitations period as the primary offense. So aggravated assault, you have to go back and look at what the statute of limitations is for assault. So when we're talking about aggravated assault, we're dealing with offenses that an individual has caused, sustained serious bodily injury, which is injury likely to result in permanent disfigurement, death, impairment of certain uses of the body, as well as, or if a deadly weapon was utilized. This is also looking at for assault, family violence. Again, those are critical offenses that are it's so hard to prosecute because victims need time to be able to process and be away from their abusers and courage and therapy and things like that before they are actually willing to come forward. And so continuous family violence is obviously, and so that's when you have multiple offenses of assault during a 12-year period or 12-month period. And what this bill does is it's actually putting on parity with other major offenses the same statute of limitations. It is allowing us to be able to have time for victims to, number one, heal, number two, understand the nature of their injuries that they have sustained, and to allow law enforcement who may go years without being able to identify a suspect either because of memory issues or evidentiary issues, and it allows them the time to properly investigate. My case came about because I had an individual who was intentionally infecting women with HIV. They did not know that they even had HIV, one of them until she was in full-blown AIDS paralysis. And we wanted to charge that as an aggravated assault. And I was stuck with a 2-year statute of limitations. It took 6 years before she got to that point. But there were multiple victims in that case that the defendant ultimately confessed to intentionally infecting with this disease that they couldn't have known. And there's no way they could have known until the time period for which the statute of limitations would have passed. And so I'm asking for this committee to please vote this bill out favorably to provide justice for victims, law enforcement time to adequately investigate and seek justice overall. Thank you.
Thank you.
I'll be happy to answer any questions you may
Sure.
have.
Members, do we have any questions for the witness? No? Okay. Thank you so
thank
much
you.
for being here. The chair calls Jennifer Catchell. Thank you for being here.
Thank you. Good afternoon. Thank you, Mr. Chairman and members. My name is Jennifer Catchell, and I am here on behalf of Dallas County District Attorney John Curzo. I have been a prosecutor in the Dallas District Attorney's Office for the last 16 years. I am testifying in support of House Bill 467, focusing specifically on the provision regarding the statute of limitations of aggravated assault. As you heard from our previous speaker, currently the statute of limitations for aggravated assault, again, crimes involving deadly weapons or crimes in which victims have suffered serious bodily injury, is 2 years. The change in the law is needed to bring this felony offense statute of limitations on par with other felonies and put victims of this crime on equal footing with victims of other felonies. It also will allow time for thorough investigation and filing of cases by law enforcement. Because this serious offense is currently the same statute of limitations as misdemeanors, there's often confusion on the timeline for the police filing the case with the DA's office. An example of a case that we had in Dallas, the victim was a 62-year-old veteran with many health conditions. He was severely beaten. He had a fractured jaw, fractured cheekbones, and lost a tooth. Although it was not definitively tied to the assault, shortly thereafter, he suffered a stroke and was moved into a nursing home. The suspect was not initially apprehended. The case was filed after 2 years, so we were unable to prosecute the appropriate charge of aggravated assault in that instance. For these reasons, we encourage you to approve House Bill 467. Thank you very much for your time.
Thank you for your
Any
time.
questions?
Members, do we have any questions for the witness? Okay. Thank you so much for your time.
Thank you very much.
If there's anyone else who wishes to testify on, for, or against HB 467? Okay. If not, the chair recognizes Speaker Craddock to close on their bill.
Mr. Chairman, members, thank you very much for hearing the bill. We appreciate it. As you can see from the DAs from the different areas of the state, they support it. And I think this bill was worked out last session where everybody seemed to be for it. I don't remember anyone against it. Appreciate you doing this today and having us up, and we'd appreciate an aye vote for it. Thank you very much.
Thank you so much for your time. Any questions?
Thank you all.
All right. Thank you so much. If there's no objection, the bill resolution, oh, sorry. Okay. If there's no objection, HB 467 will be left pending. Is there any objection? The chair hearing none, HB 467 is left pending. The chair lays out HB 311 and recognizes Representative Senfronia Thompson to explain the bill.
Mr. Chairman, may I present that bill from this position, please?
Absolutely. Yes.
Thank you so much. Mr. Chairman, members, this is a piece of legislation that we're trying to fix what is called the Michael Martin Act. And what we're trying to really do in this particular piece of legislation that is to follow the law and to be sure that evidence that that are relevant or maybe could or could not convict the defendant is turned over to them. Michael Martin was a person who had been convicted of the murder of his wife, and he served some 25 years in the penitentiary. And through DNA testing, it was discovered that he was really not the killer, but there was somebody else who was the killer. And after spending 25 years, he finally got an opportunity to get out. And the real perpetrator of the crime was convicted of that offense. This bill aims to protect employees who refuse to violate the Michael Martin Act from retaliation by their employer by authorizing civil damages against prosecutors' office who violate the law or who terminate employees for refusing to violate it. It also clarifies that post-conviction discovery shall be provided in convictions that occurred before 2014. I'm happy to answer any questions that the committee may have, and I'd like to reserve the right to close, please.
Thank you, Representative. Members, do we have any question for Representative Thompson? No? Okay. Thank you very much. Okay. We'll proceed to testimony on this bill. The chair calls Emily Schurman. Sorry. Emily Schurman. Okay. The chair calls Benjamin Wolf. Thank you for being here today.
Good afternoon. My name is Benjamin Wolf. I'm the director of the Texas Office of Capital and Forensic Writs, and I'm here to testify on this bill. With the passage of the Michael Martin Act, Texas became a leader in the nation in discovery. But there was a confusing anomaly in this case, one that Representative Thompson referred to at the end of her remarks. The Michael Martin Act was spent 25 years in prison for a crime he did not commit, but some because of vagueness in the current statute, some prosecutor offices in the state of Texas believe that it only applies to offenses committed on or after the date of passage, the effective date of January 1st, 2014. And so the confusing anomaly is that the Michael Martin Act wouldn't have applied to Michael Martin himself because his case he was wrongfully convicted and incarcerated for 25 years. There's inconsistent policies and practices in different prosecutors' offices across the state. Many embrace open file discovery, irrespective of the date of the offense. However, some route the post-conviction file review requests through the Public Information Act, which exempts many things from disclosure. This bill would clear up the confusion in the law. Thank you.
Thank you very much. Members, do we have any questions, Mr. Wolf? Okay. Thank you very much for being here. Is there anyone else who wishes to testify on, for, or against HB 311? If not, the chair recognizes Representative Thompson to close on her bill.
Mr. Chairman, members, we just seek to have uniformity in the law and that the law be followed for both post-convictions investigation as well. And you won't hurt my feelings if you want to vote it out today.
Thank you, Representative. I think we have to keep it pending and for all the entire committee to vote on it. So thank you so much for being here. Is there any objection for HB 311 to be left pending? Hearing none, the chair make the HB 311 will be left pending. Thank you. Right. The chair lays out HB 412 and recognizes Representative Sanfronia Thompson to explain her bill.
Mr. Chairman, members, I want to thank you for allowing me to come before this committee with this particular bill. Last session, we had an enormous public outcry on the need for police reform after the death of George Floyd. And while time has passed and while there are not hundreds of people in the Capitol today supporting this bill, the need for common sense police reform remains. This bill calls for the cooperation of testimony for police officers in undercover narcotic cases, just as cooperation is required for informants. This is a rule that has been in place for over 2 decades for non-police undercover informers and is well established and appropriate verification to prevent the conviction of innocent people. We have unfortunately had some rogue officers falsify testimony, and it can take years to notify victims and unravel convictions. You may recall the situation, some of you may recall the situation in Harris County. I know Representative Bowers remembers this one, in the Heights area where police officers falsified an affidavit and went in for a drug burst, killing the couple, and there were no drugs. But he led officers to believe that there were. Subsequently to that, it was later found that he may have urged other affidavits. And so it's costing the taxpayers thousands and thousands of dollars to unravel those cases and let those people out of prison or to clear their records up for having been falsely accused. So all we want to do is we want to make sure that when officers give testimony that is corroborated, and when prosecutors get that information, they can rely upon the veracity of that information. And this measure passed the Texas House last session, but it unfortunately died in the Senate. And I want to thank you and the committee for listening to this, and I'm available for questions if you have any.
Thank you, Representative. Members, are there any questions for Representative Thompson? If not, we will proceed to testimony. The chair calls Kathy Mitchell. Thank you for being here today.
Hi, my name is Kathy Mitchell. I work with a group called Just Liberty, and I feel like I've been working on this bill my whole life. I'm going to try to stay on.
Testifying on, for, or against?
For.
Okay,
thank you. I'm going to try to stay short, but I do want to describe a little bit of where this all came from and why it's current and urgent. On July 23, 1999, we all learned of the arrest of 47 people on drug charges in the tiny community of Tulia, Texas. Tom Coleman, an undercover narcotics officer associated with a poorly managed regional narcotics task force, was given the status of hero across Texas. The case is hinged entirely on his testimony. The first trial, Joe Moore, an old guy who lived in a shack and drove a rusted out sedan and insisted he was innocent, got 99 years from a jury. Once people saw enormous long sentences on these simple drug cases, they all started to plea. Once one person was able to prove with documentation incontrovertibly that they could not have been where Tom Coleman said they were, exchanging money for drugs, the cases started to fall apart. I have to mention a legendary Amarillo criminal lawyer who has now died, entered the cases at that point and began to file appeals. As the credibility of Tom Coleman fell apart and appellate courts started to take notice of the briefs, change began for those Tulians. In 2001, Senator Van de Putte and then Representative Chuy Hinojosa filed the first bill to require in drug cases corroboration of the testimony of a single accuser, any accuser. And the bill met with an enthusiastic response from most lawmakers on both sides of the aisle. It eventually passed after a tough floor fight in which a lawmaker added an amendment to exclude peace officer testimony. The Tulia bill no longer applied to Tulia. It was argued then, and it will be argued now, most likely, that Tom Coleman was a one-off, that Tulia is an old case, that officers can be trusted. The truth is, we just don't know. We know that the passage of this original Tulia bill in 2001, even as amended, uncovered a big problem that no one knew existed at the time. Upon implementation of House Bill 2351, when DAs had to go firm up their cases based on single witness testimony, it was quickly revealed that in Dallas County, CIs used by district attorneys and certain police officers to secure hundreds of convictions had falsely set up at least several dozen innocent people with fake narcotics. This is known, and you can look it up, as the Dallas sheetrock scandal. Nearly 90 cases were dropped after it was determined that more than half of all the cocaine seized by the Dallas Police Department in 2001 was fake, along with more than a quarter of the meth. In dozens of separate field tests, Dallas police had claimed to find positive results for cocaine, where later analysis proved there was none. The field test kits had subsequently been misplaced. Meanwhile, over the next few months, as district attorneys continued to work under this new requirement, which mostly meant the drugs must be proven to be real, but can also involve review of body camera video or any other corroborating evidence, cases were dropped and officers were indicted in the counties of Floresville and Denton. Chairwoman Thompson has already mentioned Houston. The tragic Harding Street raid has unraveled another host of narcotics cases. It is too easy for one officer willing to, Ms. T said fudge, that was very kind. One officer willing to make claims that are not true on an affidavit ruins people's lives. People never recover. And I want to mention one more. I know I've gone over time. George Floyd was one of those people. We will never know the impact that that false conviction had on his life. We do know that when he finished with it, he left Texas. All of these things have impacts far beyond what we can know And it's critically important that we put tools in place to prevent these things from happening in the first place. This is a tool that has been proven to work.
Sure. Thank you, Ms. Mitchell. I just want to clarify, I know you mentioned another bill, but you're testifying only on bill that's in front of us today, which is HB 412, right?
Yes, that other bill passed in 2001. So,
Thank you very much. Members, do we
Thank
have any
you.
questions for Ms. Mitchell? No? Okay. Thank you very much. Thank you for your time. Oh, yeah, there's, Ms. Mitchell, there's one question. Thank you.
Thank you,
Yes,
Ms.
ma'am.
Thank you, Ms. Mitchell, and thank you, Mr. Chairman. I'm just, wondering, this may be a question for Chairwoman Thompson. I'm just wondering, like, what are some of those steps that we can take, if you can spell that out, to make sure that this doesn't keep happening?
Yes, this bill does an enormous service to Texans. Passing this bill is a critical step. What it will require, it will end the possibility that a person can be convicted merely on the word of a police officer. That is what it does. So when we passed that with respect to other kinds of testimony in drug cases, we immediately determined that there were many false cases that had been made against people. And this just adds those police officers who have also been doing that to that list where the case cannot move forward without corroboration for that testimony.
Thank you, Ms. Mitchell.
Thank you so much, Representative Bowers.
Thank you.
Is there anyone else who wishes to testify on, for, or against HB 412? If not, the chair recognizes Representative Thompson to close on her bill.
Thank you, Mr. Chairman, members. I know that a lot of people may have recalled this little town called Tulia, Texas. It's where it was predominantly a lot of all the African-American people in that community was almost sent to prison falsely. But we had an officer named Peanut in Houston, and I know Representative Wu remember that. There were thousands of cases that the district attorney had to go back in time and dismiss because he literally lied on people. He lied on them and got them convicted, got them sent to prison, and it took several years to get people out of prison and clear their record up for lying. There are some good officers, but there are some who just will not follow the law themselves. So all we're asking is, if you're doing drug cases, get somebody to cooperate what you're saying to us. That's all we're asking. And that's not very hard to ask. Mr. Coburn in Tulia, Texas was even honored by Governor Bush. He had made him a star. And yet he even marred the reputation of the governor with his lying, which is horrible. So make sure you recommend this good bill for passage.
Thank you, Representative Thompson.
I close.
Thank you. Is there any question? Yes, Representative Bowers has a question.
I just want to hear more about, upon release, Representative Thompson, because it would be retroactive. It would go ahead and release people, right?
If they find out the police officer had lied on cases and stuff, they could release. But let me tell you what another aspect is. It costs not only the taxpayers the time and money for them to have gone to court in the first place, but now you're going to have people coming out and says, I was wrong for getting and convicting and collecting on us. So it costs us a whole lot of money, an enormous amount of money, and it shouldn't be.
Thank you. Thank you for this good bill.
Thank you, Representative Thompson, Representative Bowers. Is there any objection to having HB 412 left pending? Hearing none, HB 412 is left pending. Thank you. The chair lays out HB 504 and recognizes Representative Wu to explain their bill.
Sorry, old man pains. All right, thank you, Chairman Johnny. Let's see. I'll make this as easy as possible. Speaking of Harding Street, back like 4 years ago now, we had a police raid on Harding Street that resulted in the deaths of two innocent homeowners, and like we were talking about before, it's related to falsified police warrants. But that's not what we're talking about. This is all about what we call no-knock warrants. The concept is that it is a type of warrant that allows police to basically kick down a door and get into a home without announcing that they're there. And we've seen this come up not only in Houston in the Harding Street raid, but also in the Breonna Taylor story. Of both situations, police are basically at the wrong place. They don't announce that they're coming in, and all the homeowners know is there's people outside who are trying to break in, and they're violently kicking down the door. And so, like many Americans, if you're a gun owner and you believe that you have a right to defend your home, sometimes you start shooting, and you shoot first and ask questions later, which is not something that's really all that unusual if you think your family's under threat. So what this legislation does essentially, it just says, is not a complete ban. This is a compromise bill that we worked out, and then I'll talk a little bit more about the procedural history of what we did last time. But essentially, this legislation just says, as a general rule, you're not supposed to use no-knock warrants. But if you absolutely must use one, we want to make sure that your chief of police, your sheriff, or whoever is the head agency office in your agency, or head office in your agency, gives a written approval. That's it. We just want some accountability. This is actually, in fact, the policy that the Houston Police Department took after the Harding Street raid. And in like the 4 years, I think I can be corrected if there's resource witnesses that can correct me if I'm wrong. In the 4 years that they've implemented this policy, which this bill is based on, they've not done a single no-knock warrant. They've not done a single no-knock raid because it's unnecessary. All you have to do is just shout, "Police, we're coming in," right? That's it. That's all it's asking for. If it's not a no-knock, it's just a regular warrant, and you just. Anyway, so last session, this went out of CJA unanimously. It went onto the floor. It was voted out. It went to the Senate, voted out, and they got caught up behind a lot of stuff. It was one of the hostages that were taken between the House and Senate, and unfortunately, we ended up shooting the hostages. So we're trying it round two. The version that we have you have before you is the compromise. This is the compromise bill that was worked out with all jurisdictions and worked out with small counties versus large counties. And so if there's anything, if anyone has any problems, they have not come to us and said we have an issue with it, and we're hoping that's a good sign because this is exactly what we worked out last time. So that's it.
Thank you, Representative Wu. Members, do we have any questions for Representative Wu? No? Thank you so much. We'll proceed to testimony. The chair calls Hasib Abdullah. Thank you for being here.
Thank you. Good afternoon, Chair, members. My name is Hasib Abdullah. I'm a resident here in Texas. I am testifying only on my behalf, and I am testifying for House Bill 504. I don't have much to say. I think this is a very moderate bill, as Representative Wu said. It takes into account both sides' issues, or concerns, I should say, regarding this issue. I've asked for a quick passage of this bill just because I believe Texas can be a leader in this no-knock issue debate that's going on right now in this country. Thank you. Thank you for your time. Thank you for your service.
Thank you very much. Members, do we have any questions for witness? No? Okay. Thank you. Okay. Is there anyone else who wishes to testify on, for, or against HB 504? If not, the chair recognizes Representative Wu to close on his bill.
Thank you. And this is what I said last time when I presented this on the floor is, look, we can have a right to bear arms. But that right is sort of like meaningless, especially when it comes to your home, if if you don't know, you can get in trouble for defending your own home. That's kind of it. It's like there's a balance between those two things of being able to basically defend your own home, and then dealing with police coming in. We're trying to find some kind of balance to that, and that I think this is this bill.
Sure, thank
And
you.
that's it.
Members, any questions for Representative Wu? If not, okay. Is there? Sure, yes, you have one.
Oh, no, I was just saying we're glad to see you back and refile this legislation. Thank you.
Thank you. Is there any objection to having HB 504 left pending? Hearing none, HB 504 will be left pending.
Do me sit down? No worries.
Thank you. The chair lays out HB 946 and recognizes Representative Dutton to explain his bill.
Thank you, Mr. Chairman and members. I generally have a bill packet, but I've heard this bill so many times, I remember everything in it. But thank you for hearing this bill. Essentially, what this bill does is we have, in the legislature, we have spent a number of years, a number of sessions, trying to ensure that what happens on the street involving police and citizens is viewed on camera. And that's why we started requiring them to have body cams and the like. That's why you see all these things on television that happen between citizens and police. But what happens when somehow or another the camera gets turned off? And what's interesting about that is that there's a doctrine in the law called the spoliation of evidence. And actually, it's used more in the civil side than the criminal side, but it had its origins on the criminal side. Because the thought was that if you allow the evidence to go away, either mistakenly or intentionally, that ought to accrue to the benefit of the defendant. And so that's what this bill does. This just says that if there's an intentional cutoff of the cameras, that when that happens, the evidence that's not there, the whole presumption is that it was done so to the detriment of the defendant, and the defendant will have some benefit from that. So that the judge can either instruct the jury in that case, or the worst is that the whole thing will somehow or another end up being dismissed because there's no evidence, because the evidence got destroyed. That's essentially what it does, and I'll be happy to answer any questions. I don't think this is a bill that law enforcement will necessarily like, because, sometimes there are benefits to evidence not being there. But I think most of the citizens who come in here to testify to you or to testify as witnesses will tell you that, wait a minute, that's not fair. And so what this does is create a fairness in the whole system for collection of evidence, and when that evidence is spoiled.
Okay, thank you, Chairman Dutton. Members, do we have any questions for Chairman Dutton? No? Okay.
All right,
Thank you. We'll proceed to testimony. Is there anybody who wishes to testify on, for, or against HB 946? If not, the chair recognizes Chairman Dutton to close on his bill.
Thank you, Mr. Chairman. I guess I've been doing this so long, I wore them all down. But anyway, this is a great bill. This is a great way. It doesn't do anything, doesn't do harm to anybody. It just says that we're going to make sure and ensure that when we're requiring that cameras stay on, they stay on. Thank you, Mr. Chairman.
Thank you, Chairman.
And members.
Is there any objection for HB 946 to be left pending? Hearing none, HB 946 will be left pending. The chair lays out HB 519 and recognizes Representative Wu again to explain his bill. Thank you. Thank you for your patience.
Thank you so much, Mr. Chairman. And bill is very simple. It just says that if a grand jury no bills your case, saying that there's not even probable cause, a grand jury does not believe there's even probable cause for you to be arrested or for you to be charged, then you should have those records expunged. That's it, right? If you're found not guilty by a jury, you get to clear your record, right? Completely. That's it. Period. And I think if a grand jury comes in and says, no bill, we don't even believe that there is even probable cause, that there is even a likelihood that there was a crime committed, you should be able to clear your record. That's it. I think that's pretty simple, straightforward. I know there's some people who don't like this, and I'm kind of curious to why.
Thank you, Representative Wu. Members, do we have any questions for Representative Wu?
Yes, thank you, Mr. Chairman. Representative Wu, what are some of the challenges those who were arrested but not indicted face?
Yeah, so I mean, the biggest issue with this stuff is being able to essentially take certain things out of the public record. If the person was charged and then later on no billed, their charge would still be sitting there. Their bail records, their bond records, police records, all sorts of types of evidence and stuff are still out there. It could be held against a person. And when, in fact, a lawfully convened grand jury has said, no, we don't even believe that there is even a suspicion. There's not even enough to indict, right? Which is, and as you may have heard, it's as easy to get an indictment as the DA's going to indict a ham sandwich, and we've heard that time and time again because, pretty much they get the prosecutors get to present anything they want to a grand jury, and it's hard not for a grand jury to bite. And if a grand jury won't even bite on that, I think we should let people be able to clear the record. Right? That's it.
Thank you, Representative Wu. Thank you, Representative Barros.
Thank you.
We'll proceed to testimony. The chair calls Joanne Cawthorn. Okay, the chair calls Hasib Abdullah.
Chair, members, I'm still Hasib Abdullah, still in Central Texas. I am testifying for House Bill 1519, just because I was actually surprised that
519, right?
519, right? Did I say that? Okay, I'm sorry.
Thank you.
519, and I think there's unfortunately no Senate version of this bill, I don't believe, but I really was shocked that in the state of Texas, we don't have this right now. And the fact that the concept of you're innocent until proven guilty is a very core concept of American criminal jurisprudence. Not every other country has it. Not every democratic country has it. But I don't have much more to say. I just think Texas is handicapped and on the wrong side of history and justice by not having this. I hope it would be quick passage and get to the Senate and to the governor's desk. Thank you for your time. Thank you for your service.
I just want to clarify, Mr. Abdullah, that this is you're testifying on the bill that is in front of us, HB 519.
Yeah. Did I say that? Or
Yeah, I just want to we just want to make sure it's clear.
yes, sir.
Thank you. Thank you very much.
Thank you.
Is there anyone who wishes to testify on, for, or against HB 519? If not, the chair recognizes Representative Wu to close on his bill.
Thank you so much. And this is the consideration for the injustice of this. So if you actually had a grand jury actually indict, and then you took the case to trial and you were found not guilty at trial, you could clear up your record, right? But if the grand jury didn't even think that there was enough to indict, now you're screwed. And we just think this is it's just flatly unjust. And this is, as a reminder, this process is an application. I mean, the judge has a say about it, the DAs have a say about it. And, you know, I think it's a fair process to give people the opportunity to have their records cleared if they're no build. So, and if there's anyone out there, I know there's some people who put in some no's, opposition to this bill. They've not come talk to us. And if there's anyone who wants us to work on this bill with them, we're happy to do so. If you oppose to this bill, come to my office and come talk.
Vice Chair Cook, you want to have a question?
Yeah, Mr. Wu, I just wanted to, I guess, ask a couple questions about the language itself. I mean, 'cause it's obviously a very small change, but what you're saying is not what I'm seeing in the language. And so, this is probably because I do not practice criminal law, but is the only issue that's ever presented to a grand jury is whether or not probable cause exists? Is that the only issue? I mean, because I would think that based on what I've heard today, it would make more sense just to say that the grand jury, you know.
Yeah, the presentment did not occur solely because the grand jury failed to find probable cause existed.
Because what I heard you talk about is no bill, and there's a difference. I mean, just saying, like, to me, it seems like if the grand jury no billed you, then you're entitled to this relief. I mean, that seems like it would be more just, I don't know what all this means. So.
Yeah, I'll double check with the attorneys, but when I think of no bill, this is the grand jury came back with when the grand jury comes back and finds there's no probable cause. I think that is a no bill, unless I'm wrong.
Okay. Yeah, just we can get a clarification. I don't know the answer to that. Like I said, I do not practice, never presented a case to the grand juries, but it seems like
it's been a while since I've taken one.
Yeah, I just would want to make sure that that your intent is what's spelled out in the bill. Thank you. And I do support the concept. I mean, it's common sense.
We will clear it up.
Yeah, thank you.
Thank you, Vice Chair Cook. Thank you, Representative Wu. Is there any objection to HB 519 to be left pending? Hearing none, HB 519 will be left pending. Thank you. Okay, I just want to recognize Chairman Darby for coming here and sitting on the dais. Thank you. Yeah, feel free to ask questions, please. Thank you. Okay. The chair lays out HB 399 and recognizes Representative Collier to explain her bill. Thank you for your patience.
Chair Boujani and members, over 9 million Texans have criminal records that may show up on a routine background check from either an arrest or a conviction. This figure also includes thousands of Texans who have successfully completed a period of deferred adjudication community supervision for nonviolent, non-sexual misdemeanor offenses. Misdemeanor case records are permanent. There is currently a pathway for individuals on deferred adjudication for a first-time nonviolent misdemeanor offense to have that record sealed, but that pathway is limited. Under current law, Section 411.072 of the Government Code codifies the procedure for orders of non-disclosure for individuals who commit certain nonviolent misdemeanors. If a person has a conviction on their record, they are not eligible for an order of non-disclosure unless that conviction was for a traffic-only, fine-only offense. That's the current law. Also, if a person already has an order of non-disclosure, they can't request another one because the law does not allow it, even if that current offense would have been eligible for non-disclosure otherwise. In order to change this, HB 399, if passed, would automatically grant orders of non-disclosure of criminal history for certain misdemeanor defendants following successful completion of deferred adjudication, sealing their records from public view. Law enforcement agencies, though, they will retain access to these records, ensuring relevant information remains available. Additionally, it's important to keep in mind that this bill does not change the fact that orders of non-disclosure are only for non-violent, non-sexual misdemeanor offenses and anyone with a felony conviction is not eligible. And they still would not be eligible. Therefore, if a person has a conviction for murder, assault, crimes involving a weapon, kidnapping, robbery, and sexual assault, to name a few, they still would not be eligible for order of non-disclosure. This bill does not change that. With a misdemeanor on one's record, though, a person will face significantly more barriers when trying to access gainful employment, whether they also want affordable housing and key educational prospects. House Bill 399 will take a significant step towards ensuring that a past decision does not limit their future potential. And I do want to remind everyone that this bill did pass out of this committee and pass on the House floor. Chair Darby, you voted for this bill last session, and I ask for your favorable consideration at this time. And with that, I'm open for questions. Otherwise, I'll reserve the right to close.
Thank you, Representative Collier. Members, do we have any questions? Vice Chair Bowers.
Yes, Mr. Chairman, thank you. Representative Collier, how will a defendant know that the non-disclosure needs to be filled out? How do they find out that they need to do that?
Sure. So this would be going forward. It only applies if the bill passes, it only applies to those crimes that happen from then on. And at that point, once they complete their deferred adjudication plan, whatever it is that they were required to do, then they would be eligible. At that point is when they would be able to request. And so you don't tell them before. You want to make sure that they complete it. So at the time that they completed their obligations, that's when they would be told. And they have to pay all their fines and everything. The whole thing has to be completed, whatever it is, the plan.
And then how often do you see, does it prevent individuals from gaining employment? How often do you have numbers on that?
Yeah, I don't have the numbers right here in front of me. We may have a witness that can talk about that, but they face significant barriers because so many potential employers do background checks. And so an arrest will show up on your record. It doesn't distinguish between whether it was, received deferred adjudication, whether it doesn't even tell you if the case was dismissed. Because of these records being permanent. So it does have barriers, even when somebody's applying for college, housing, all of this can show up on their record. But if we can give them that opportunity to have, once they have completed their obligations, then they should have that opportunity to seek a second chance at clearing their record.
And how quickly do you hope the bill will achieve the foreseeable changes that you want?
Oh, right away. I hope that I think that, once the bill passes, those going forward will have this opportunity to have this, their records sealed. So that way they can continue on and get back on track with their life.
Well, thank you for this bill. Thank you.
Thank you. Maybe if you let them know in advance of them finishing up their community service, that may be an incentive for them to finish it also, right?
I believe it would be the same time that they tell them now, for those who are eligible. Absolutely.
Thank you.
Yeah, you're right. I think that's a really good point. Thank you.
Thank you. Members, any other questions? Okay. If not, we'll proceed to testimony. Thank you.
Okay.
Chair calls Sarah Mae Jennings.
Good afternoon. Thank you, Chair Bojani and members. My name is Sarah Mae Jennings. I'm the Interim Co-Executive Director and Policy Director at the Texas Fair Defense Project. I'm here today in support of House Bill 399 on behalf of TFDP and myself. House Bill 399 will remove the first offense barrier for an order of non-disclosure under Texas Government Code 411.072. 1 in 3 Americans has a criminal record, including millions of Texans. Individuals with records face lifelong barriers to employment, housing, public assistance, educational opportunities, and more. In Texas, we have 2 types of record clearing for adult criminal records: expunctions and non-disclosures. An order of non-disclosure seals a record or portion of the record from most of the public while remaining available to sensitive fields, including law enforcement agencies, financial institutions, healthcare institutions, and licensing agencies. Non-disclosures are generally available after successfully completing a special type of community supervision called deferred adjudication. Successful completion of deferred adjudication means that the individual has spent time in their community working, contributing, and caring for themselves and their families. Texas Government Code 411.072 non-disclosures are the only type of non-disclosures that are already presumptive under the law, meaning that they are more streamlined than other types of non-disclosures. Under current law, 411.072 non-disclosures are only available for a single first-time misdemeanor offense. House Bill 399 seeks to remove the first offense barrier so that more successful completions of deferred adjudication for nonviolent, non-sexual misdemeanors are eligible for streamlined non-disclosure relief in Texas. House Bill 399 would allow more Texans who have successfully completed deferred adjudication for those nonviolent, non-sexual misdemeanors to obtain a streamlined non-disclosure under Texas Government Code 411.072, allowing more Texans to access improved employment and housing opportunities for themselves and their families. Thank you. I'm happy to answer any questions.
Ms. Jennings. Members, do we have any questions of Ms. Jennings? No. All right. Thank you very much for your time.
Thank you.
Chair calls David Emmerich. Thanks for being here.
Mr. Chairman, members of the committee. I'm Dave Emmerich, Regional Director for State and Local Government Relations for JP Morgan Chase. And I'll just take a couple of minutes to talk about the employer side of this and how we look at this. JP Morgan Chase is one of the, I'm sorry, for the bill. Okay, thank you for the bill in support of it. We're one of the largest employers, private employers in the state with over 30,000 employees. Several years ago, we initiated a program where we actually banned the box when we started looking at employees for doing that in their applications. So when we actually go through the application process, we don't do a background check until we're ready to make an offer. And so what we're finding with that is we're getting employees that are very good employees, they're very strong employees, they're very dedicated employees. We've also been able to engage a number of organizations and large corporations in the country through the coalition called the Second Chance Business Coalition, which we helped found. Those are some of the largest employers in the country. They're in every neighborhood in every state, just about, and working with them to help them educate the need for second chance employees. What we found is that the question I think came up earlier about the number of employees and how that impacts them, the ability in that background check. Getting that background check, so over 8 million Texans roughly have criminal records, about 1 in 4. Of those, about 35% of them are eligible to get their records sealed. Of that amount, about 5% go through the process. It's time consuming, it can be expensive, it can be complicated, it can be confusing. And the fact is, most people just don't go through it because it's difficult to do so. Having it records sealed automatically for those records makes it easier for them. It helps them become employees are great. It brings in tax revenue, helps them support their families. It gives them jobs. It gives them career pathways they may not otherwise have. So we do support the bill. We think it's a great bill. Would urge the committee to support it. I'd be happy to answer any questions.
Thank you, Mr. Emmerich. Appreciate it. Members, do you have any questions for Mr. Emmerich? No? Yes. Mr. Barbers.
Thank you, Mr. Chairman. Thank you, David Emmerich, for your clarification and for some of the numbers and talking about the pathways that are cleared. And you mentioned something that you all started. It's called a Second Chance.
It's the Second Chance Business Coalition. I'd be happy to come to your office and spend some more time with you, but there's a website that you can go to. It lists about over 40 coalition or corporations now, large employers that are part of the coalition to help educate and bring them on. Many of them have supported similar legislation in other states. This would be one of the I think there's about 11 states now that have passed, or 6 states now that have passed it, with another 4 or 5 now looking at it this year. So this is not a new idea, but they're helping work on some of the policy issues and across the country to deal with second chance hiring, to help educate employers about the need for second chance hiring, to help those get a foothold in the door to get them a job.
Yes, thank you so much for that. Thank you.
Seems like a great program. Thank you so much for doing this. All right. Is there anyone else who wishes to testify on, for, or against HB 399? If not, Chair recognizes Representative Collier to close on our bill.
Thank you, Mr. Chairman. I have room for some joint authors if you'd like to join on this wonderful bill. And with that, I ask for your favorable consideration, and I close.
Vice Chair Cook has a question.
Oh, yes.
Just have one question. Is there any limit on these? I mean, like, is there any way to limit this,
The number?
second, third, fourth, fifth, sixth chance?
Well, I don't see that there's a limitation on here. I did not read that into the bill, but I think it's not in this bill. Maybe it's in another section of the code where it talks about the first offense. You can't, if you have one offense, then you can't have
5 years. I mean,
yeah, 5 years, yes. But for the non-disclosure, I don't see a limitation on whether you can get like 5 or 6 non-disclosures. Is that what you're asking me?
Yes, ma'am.
I did not read that in there. Is that cause pause for you?
Yes,
For
ma'am.
nonviolent? So let me give you an example. So say, for instance, I'm 20 years old and I got a graffiti offense. I got charged, convicted with graffiti, which is a misdemeanor. And then, I'm on the straight and narrow for the next 20 years. And then I get a public intoxication because I'm out hanging out with my friends one Saturday night. Because I had that graffiti, I'm not eligible to get that public intoxication. And so this is the type of individual that I'm trying to focus on. Somebody who just maybe went out and overindulged or something, didn't make a good decision that time. Why are we tying the hands of, why are we preventing them from getting their second chance just to, get back on track because of that first conviction 20 years ago? That's what the concept is. And right now, I'm not of the opinion that I haven't said that we should just limit it to 1 or 2. But I'm going to look at the rules.
For a second chance, but probably not 5th or 6th or 7th or 8th.
Well, to be on deferred adjudication, I think maybe it's a 6-month period at least.
It depends.
Yeah. So if they're on there and they complete that and they've been doing good, would you feel more comfortable if there was a time period, or what if there was, like, you can only get one other second chance?
Correct, yeah. With that second chance for sure. I have a Fair Chance Hiring Act bill. It's also that I think David's going to testify on as well. But
What does it do?
and it's a concept that just says that public employers shall refrain from pulling a criminal background check until after they've made a conditional offer. And so, I definitely, agree with the intent of your bill and supportive of it. And it came through the Criminal Justice Reform Interim Committee that was on, I think, with Ms. Bowers. And so, I think it's a great concept. And, I do want to applaud J.P. Morgan Chase for being a leader in the private sector.
I just don't see
believe ours
that, yeah.
is HB 1215, and like I said, it only applies to public employers with exclusions for schools and law enforcement. But
Okay.
otherwise it applies to.
So it only has one chance?
Yes, correct.
Okay.
Well, not really, because no, what it is like each time, if they were to apply for, 5 different jobs, then, and those were public employers, those 5 employers would not be able to pull the background
Right.
until after they've made a conditional offer. So, so I definitely agree with the concept, but just, not unlimited.
Yeah, I'm interested. You know what, I'll look into that because I wonder how often somebody's getting, because eventually you become a habitual criminal after you have so many misdemeanors.
Right.
So I think that would put you out of it anyway.
Not according to the way I read the statute.
Okay, let's talk about that.
Okay, perfect. Thank you.
Thank you. Thank you, Vice Chair Cook. Thank you, Representative Collier. Vice Chair Bowers has a question, sir.
Thank you, Chairman Bojani. I'm glad, I agree with you, Vice Chair Cook. I'm glad my son works for such a great company as J.P. Morgan Chase. And my only question is, could I get the JA on line 1? Because you have line 1 left.
Absolutely.
Thank you. Thank you for this piece of legislation.
Thank you, Vice Chair Bowers. Thank you,
Okay,
thank you,
thanks.
Representative Collier. All right. Is there any objection to having HB 399 left pending? Hearing none, HB 399 will be left pending. Thank you very much. The chair lays out HR 4. The chair lays out HB 414 and recognizes Representative Collier to explain her bill.
Yes. I'm going to take a little bit of time on this one, so thank you so much, Mr. Chairman and members. This year marks the 50th anniversary of Gideon versus Wainwright, the landmark U.S. Supreme Court decision that said the Sixth Amendment requires every state to provide attorneys to criminal defendants who could not afford their own counsel in order for them to have an adequate defense. Under Texas law, an indigent defendant is entitled to appointment of counsel in any adversary judicial proceeding that may result in punishment by confinement, including on direct appeal. This would include charges for Class A and Class B, misdemeanors, or juvenile cases, and of course, felonies. But the question of adequate defense does not rest solely on whether or not a defendant has access to counsel. It also rests upon whether or not that attorney has the time and the resources necessary to provide effective counsel. The Fair Defense Act created the Texas Task Force on Indigent Defense, which is now the Texas Indigent Defense Commission, which I had the honor of serving on the last 2 sessions. Under the Fair Defense Act, there are four primary systems that counties use to provide legal services to indigent criminal defendants. Some counties have public defender's offices. Lawyers who work for public defender's officers are county employees, and they do not have an outside practice. Now, other counties use a contract system where lawyers agree to take a certain number of cases for a certain fee. That does give cost predictability, but it could incentivize attorneys to put in the minimum amount of work to get the defendant to plead guilty so they can get on to the next case. A managed assigned counsel, or a MAC is the other one, it's a variation of the public defender office model. Their attorneys are in private practice, and there's currently 7 MAC systems in Texas. Now, however, the majority of Texas counties use a wheel where lawyers can apply to take different levels of cases, whether that's misdemeanor, felony, and so forth. The theory of the wheel is random assignments, which was designed to even out the caseloads and the workload. One of the issues in indigent defense under the various systems has been lawyers having too much work and not enough time to provide good representation to each client. Texas law requires that attorneys who receive court appointments to report their caseloads. Now, this information is helpful when assessing the state's fulfillment of upholding our Sixth Amendment obligations. In theory, when the wheel works, it works well, and the workloads are balanced. But the main problem is that although many judges follow the wheel, not all do, because judges have the discretion to alter the assignment. Now, one thing that I found in the midst of a 2013 federal court decision entitled Wilbur versus City of Mount Vernon, Washington, it involves the effectiveness of counsel for indigent defendants, and these are the words that are found in footnote 5. Caseload levels are the single biggest predictor of the quality of public defense representation. Not even the most able and industrious lawyers can provide effective representation when their workloads are unmanageable. Without reasonable caseloads, even the most dedicated lawyers cannot do a consistently effective job for their clients. A warm body with a law degree able to affix his or her name to a plea agreement is not an acceptable substitute for the effective advocate envisioned when the Supreme Court extended the right to counsel to all persons facing incarceration. That's the end of the quote. Now, there's no perfect system. Each has their pluses and minuses. But what we're seeing now reminds me of that old I Love Lucy episode. It's when her and Ethel are doing the chocolates, and it's coming down slowly. It's one of my favorite episodes. And you see Lucy, they start picking up, and they have so many chocolates that they don't know what to do. They start stuffing in their mouth, in their pockets, and it's just overflowing. And that's what we're seeing with these cases. We're seeing lawyers take so many cases. In fact, I want to share this with you. Can I present this to you? I want to give you an example. We're seeing attorneys with so many cases that it's an overflow for one person. If you look at that diagram, in Harris County, there's an attorney. Well, I don't know if it's Harris County. One attorney had over 900 cases. Let me give you an example. In fiscal year 2022, the highest caseload for a private attorney was 964 cases. A caseload which included 449 misdemeanors, 482 felonies, and 33 juvenile cases. Now, the Texas Indigent Defense Commission has brought much progress to the criminal justice system. There's wonderful people working on that commission and through them to ensure that we uphold our duties. But there's still room for improvement. Back in the 83rd legislative session, the Texas Indigent Defense Commission was required to conduct a study. The study was published in 2015 to determine guidelines for establishing a maximum allowable caseload for criminal defense attorneys. According to the weighted caseload guidelines developed by that study, an attorney should have no more than 226 misdemeanors or 128 felony cases per year. Unfortunately, far too many private attorneys in Texas are exceeding this recommendation, as you can see in that handout. To put it in perspective, if that attorney who had 964 cases spent 24 hours of every day working, they would have spent a total of 9 hours on each one of those cases. But that's not possible. In fact, if we look to the weighted caseload guidelines, that attorney's caseload of 964 cases should have been handled by 5.8 attorneys that were full-time. Now, there are dozens more attorneys who exceeded the weighted caseload guidelines, all with hundreds of clients who should have been served by between 3 or 4 attorneys, not just one. It is impossible for every one of those clients to have received adequate representation. Without proper representation, indigent defendants are more likely to receive excessive sentences and be wrongfully convicted. I wanted to point you out to the first person on that list. They made $1 million for 95% of their practice in 1 year representing indigent defendants. And I ask you, are we doing what's right? Did they get a fair shake? So in order to lessen the chances of these horrific outcomes, House Bill 414 would direct the Texas Indigent Defense Commission to establish a maximum caseload for attorneys who represent defendants determined to be indigent. The Indigent Defense Commission would also have the authority to revise the maximum caseload as necessary and adopt rules to promote compliance with the established caseloads. And most importantly, this bill will take a significant step towards helping preserve the Sixth Amendment rights of indigent defendants across Texas. And I think we have some witnesses here, and I'll respectfully reserve the right to close.
Thank you, Representative Collier. Members, do we have any questions for Representative Collier? Okay. Oh, yes, Vice Chair Bowers.
Thank you. I just like asking Representative Collier questions. Rep. Collier, do you have any personal experience with this?
Well, I've served on the Texas Indigent Defense Commission, and this is where I learned more about the caseloads. They've done a fabulous job of collecting the data and presenting it in a manner that we can understand and also for us to act on. I mean, the information is here. So my experience has been with that Texas Indigent Defense Commission, just what I've come into contact with and learning through there.
Thank you.
Thank you, Vice Chair Bauer. Thank you, Representative. Oh, yes, Chairman Darby.
Chair Collier, just questioning, in my part of Texas, rural Texas, we recently went to a public defender model, and so I noticed that some of these public defenders have an individual names. They are public defenders, but they also have a higher caseload growth. Are you not making distinctions between those attorneys in private practice and public defenders? And would not they have the same time challenge, the same focus on individual defendants as a as a practitioner not associated with the public defender's office?
Yeah, so the public defender's office represents indigent defendants, so they would be under this too as well. So a lot of times what I've seen happen is that when you have a public defender's office, they will take so many cases, and then after that, they say, we cannot take any more cases, and then that's when they'll do a hybrid, and they'll do the wheel, or, assign the cases out. So a lot of times, that's what happens, is that they just say, we can't take any more. But the system in a public defender's office is different. The setup, you have a whole, if somebody's in a private practice, they may not have access to another attorney to talk to about the case or whatever. But I do believe that the system for the public defenders is a little different. But of course, the caseload standards should apply there too as well.
Yeah, I would think. Then what do you do in rural Texas where you don't have private attorneys willing to be a part of that wheel that you referred to? Having been a young lawyer coming out of law school 50 years ago, I was appointed on several criminal cases, and finally had to go to the judges, and I said, look, I'm gonna swear by affidavit that I'm committing malpractice by you appointing me to these criminal cases. So they quit appointing me. But I say that in jest, but there were only so many young lawyers that they could appoint to these cases. And so what do you do in small rural counties where there's just not a lot of private attorneys? And those that you do have, you work them and you put the cases on them and they try to do the best they can, but there's really nobody else available.
Well, some areas have done a fine job of creating regional systems where they do a regional assigned counsel where it's not just one county, but it's multiple counties that come together. That way they can have a list. But I visited Lubbock. I mean, they've got a great system out there in Lubbock. They have a public and private defender, and they use the system of assigning. And sometimes those attorneys in Lubbock have to travel, 100 miles away to, help other people in other counties. So that is an issue. But I think that there's ways that we can create mentorships. That's what Lubbock does. They have mentorships for those new attorneys, and, mimic that model to see if that's something that could be done as well. I mean, we saw in Operation Lone Star the difficulty of finding attorneys to take those cases, and so they got creative on how to do that. So I think that there's legislation that is coming up that could help address the limited number of attorneys in rural areas that would take these cases for indigent defendants. But we have a duty. I mean, even though there's no lawyers, we still have that obligation to meet the Sixth Amendment, to fulfill that. And so one of the concerns we have is, are they being pled so they don't have to get an attorney?
But that's why your bill is here. You're saying that there is an obligation to represent them, and there is a constitutional requirement to do so. But what you're saying is you're putting a limit on the amount of cases that an individual attorney can have at one time, and you're asking for legislation that would restrict that and thereby create perhaps the shortage of available attorneys, especially in...
Okay, I see where you're going.
You see what I'm saying?
Well, this is this is a weighted caseload guidelines. So it depends on the type of case. So I'm not saying the number, because that would be set by the commission. But it's kind of fluid, because at one point I may not have as many felonies as I do misdemeanors or capital cases. So that's why it's weighted. It's weighted against the current circumstances and the current caseload that you have. So maybe you can take so many X or Y. I just read what the recommendation from that 2015 study was about how many you can handle at one time. But I'm not familiar with a county having, there's rural counties that had 900 cases all for the whole year. That's it. Not one person taking them, but just in that whole county. So I think that if you're concerned about the shortage of attorneys, I haven't seen that arise in terms of putting caseloads. But because if you look on there, those are urban cities.
Yeah.
And I didn't see any rural cities where somebody's getting, 500 cases.
Well, again, my county went to this public defender's office. It's been hugely successful. In fact, now we have Abilene, city of Abilene, Taylor County has gone under the umbrella of this public defender's office. So it's been a very workable model, but and again, I think your bill covers not only the public defender's office but private attorneys.
And again, they would have to get paid anyway. So even if you put a limit on it, it's the same number of cases, whether you pay the public defender's office or the person that's appointed, the wheel. Okay. It's still the same in terms of if that you're concerned about the cost or anything.
Yeah, thank you.
And if somebody is here that can correct me if I made a mistake, please come up here and do that.
Thank you, Chairman Darby. Thank you,
All right, thank
Representative. We will proceed to testimony. The chair calls Nathan Fennell. Thank you for being here.
Of course, good afternoon. My name is Nathan Fennell. I'm an attorney at the Texas Fair Defense Project. I'm testifying for House Bill 414. My office works to improve access to counsel and quality of counsel for folks who get arrested and can't afford a lawyer in Texas. Before I was in Texas, I worked for the Public Defender's Office in New Orleans, and my job was to make sure that that everyone who got arrested in New Orleans, a lot of people got a lawyer and got someone assigned to them and figured out they were, someone that could work on their case. So as a big picture thing, obviously Representative Collier did a very thorough job talking about why this is important. It's simply not possible to adequately represent your clients if you have too many cases. And my office gets phone calls and letters from folks across the state that have issues either getting a lawyer or, more specific to this, being able to communicate with their lawyer. And we get so many of these calls and letters that we've created little self-help packets for folks on how to talk to their lawyers if they can't get in touch with them. And we almost always get these complaints from folks who have an excessive caseload. These aren't folks who are just disgruntled. These are folks who often have gone months, and in some cases even over a year, sitting in jail without ever being visited by their court-appointed lawyer, right? In fiscal year 2022, I just want to add a little more flavor to the numbers Representative Collier talked about. 68 lawyers in Texas closed out more than 300 felony cases. That's more than one felony for every working day that you have. You cannot do a felony case in less than a working day if you're doing all of the work that you need to do to represent someone adequately. 6 different lawyers closed out over 1,000 misdemeanor cases in a year. A 2017 study, so when people think about overburdened attorneys, some people think about it in the context of the number of lawyers. We find it's more useful to think about it in the context of the number of clients, right? So a 2017 study found that 40% of clients' cases in Texas were represented by a lawyer who had more cases than the TIDC guidelines suggested a lawyer could handle in 1 year. In 2022, fiscal year 2022, I just crunched the numbers this morning, even the most restrictive version of looking at the caseload standards says that number is still about 40%. Now, what Representative Collier's bill would do, of course, is allow the Texas Indigent Defense Commission to come up with a caseload standard and guideline. So it's not necessarily saying that the numbers we've been looking at before will be the numbers moving forward. It's saying that the Indigent Defense Commission would come up with numbers. And one thing that I really like about it is that in any situation where something might happen related to a place going over caseload limits, the instruction is that the Texas Indigent Defense Commission can issue a remedy. Now, remedies aren't always sticks. They can also be carrots. A remedy could be, we're going to look at this place and say, we're going to help you to get more lawyers into this county or into this region. We're going to help you get support staff and investigators. It doesn't have to be exclusively punishment to counties that can't, for whatever reason, get enough lawyers into them if that's actually the source of the problem. Although in many urban places, that's not the main problem, right? It's that the system is different. Lawyers with too many cases just can't do the things that are necessary for adequate representation. They don't visit their clients frequently enough in jail. They don't investigate the facts of the case. They might not research the law or file motions. And at a certain point, if a lawyer has far too many cases, really the only thing that they can do in a lot of situations is just relay the prosecutor's plea offer to the client. A nonprofit that I work closely with in Houston is called Restoring Justice, and they represent folks who've previously had a court-appointed lawyer whose caseload was excessive. And what they found is that when they take on cases, and they have caseload limits, and they found that from the last offer that the court-appointed attorney who had a very high caseload had to the final resolution they can get in the case with a caseload limit on their lawyers, the difference is 5 years on average per case. Representative Collier has talked about the case law on this, and I'll wrap up now. I appreciate your time. Other states have enacted caseload limits with success. This is not a new thing in Texas. Nevada does it. Massachusetts does it. Washington State, after being sued in Wilbur, their state Supreme Court actually put in these limits. There's a lot of variation in Texas, but the Code of Criminal Procedure is the same. The Penal Code, the Code of Evidence is the same. The Constitution is the same. There's the same number of hours in a day. Counties would be free to hold their lawyers to a more strict standard, but we're asking that the state look at least a bare minimum for the folks that are being represented that are entitled to counsel. I'd be happy to answer questions or talk later. Otherwise, I appreciate your time, and I'll stop now.
Thank you, Mr. Fennell. Members, do we have any questions for Mr. Fennell? No. Thank you so much for your time. Chair calls Stuart Riley. Thank you for your time.
Excuse me, I never done this before. But,
Yeah, if you can just mention your name and are you for or against?
Stuart Lee Riley, testifying for the HB 414.
Thank you.
I was caught up in that cycle for years, what we're talking about, the court-appointed lawyers and everything like that, where they would come and see you at court, then you would never see them. I spent 2 years behind bars fighting a case, seen my lawyer 3 times. Then I got with a small group called Restoring Justice because I fired my lawyer, and he, like 3 times, he came and seen me out almost 2 years while I was locked up. But every time I seen him, all he asked, do you want to make a plea? I'll go make a deal, but they're offering 25. And I was like, this stuff didn't happen. I'm not signing for this. Then I got with this small group called Restoring Justice. It's, I think, a promo, if I'm saying it right. They came in, did the background work. The first day shocked me. I never seen a group of lawyers do this. Went out there and did their footwork, investigated. 2 weeks later, beat the case, dismissed, went home. And now I work for them. I talk to other people, troubled kids and stuff, and substance abuse, you know, and it inspired me a lot to do better things. And I think these court-appointed lawyers are overbooked because they don't do it would be one thing if they did do the work, but when they come back, they don't even know, oh, I'm on your case? Yeah, you've seen me 3 times already. Oh, what's your name? You know, it's like they're not investigating what's going on. That's all I got.
Thank you for your testimony. Members, do you have any questions?
Thank you.
No, thank you so much for being here and for giving back as well. The chair calls Allen Place. Former Representative Allen Place.
Mr. Chairman, members, my name is Alan Place. I'm here today on behalf of the Texas Criminal Defense Lawyers Association. We're testifying on the bill. We've had a lot of conversations in the last few years with Chairman Collier.
On the bill, you said?
I'm sorry?
On the bill?
We're testifying on the bill. It'll sort of be more clear in a minute. Maybe. I'll try to be. Basically, our association recognizes best practices for representation. And obviously, we're into, COE and lawyer training. And, certainly, I'll just address the last speaker. That should never happen. It just should never happen. But there's a couple of things, and I think Chairman Darby brought up a question that we have about probably the latter part of the bill. Basically, best practices, caseload limits, I think those are something that we should have, and something that we do have in current law, as I understand it. But the issue that our members look at is if you have a one-size-fit-all situation, you're not going to address the elder lawyers like Chairman Darby and myself in terms of an experience factor with a younger lawyer, or misdemeanors and felonies, and you may be able to wait those out at some point in time. But your experience factor and your abilities are going to be different. The other thing is probably up until San Angelo probably had a PD system, you probably had a wheel system. And that's how they probably got drug in early on in his career. And that's pretty much what I think you see in rural Texas. So if you try to have a system where you have PD offices or managed counsel offices, and you also have a wheel with private lawyers, I'm not sure the one-size-fit-all caseload. I just don't know how you address that. Candidly, we've had that conversation with Chair Collier for years, and this is not the first time we've discussed this, and it is a difficult situation for an organization, like ours. I guess the other question we have is the bill does allow for rulemaking authorities, and we would probably like more information on what is the enforcement mechanism. What will that be? What will that look like? And with rulemaking authority, we're just not in a position to know. So I will say one of the answers to the last speaker's questions is I don't have any doubt indigent defense is overloaded and underpaid. And not to say that the answer to everything is money, but in that issue, that certainly is the issue.
Thank you so much, Mr. Place. Members, do we have any questions for Mr. Place? Yes, Chairman Darby.
Good to see you, Alan.
Good to see you, Drew.
It says, part of the bill says, the commission shall impose a remedy for noncompliance occurring in any county in which the commission provided for the preceding state fiscal year grant funds under section 79037 in an amount equal to more than 50% of the county's expenditures on defense services. So that, I guess, the commission could hold back grant money. How do you interpret that?
I think that's right, and certainly if you, and I understand, what do you believe that a county or a particular court is out of compliance? I don't know. It just seems sort of counterintuitive to me to potentially reduce funds to an already underfunded system.
Yeah, that was my concern. So,
yes, sir.
Thank you, Mr. Chairman.
Thank you, Chairman Darby. Thank you, Mr. Place. Any more questions? Okay, thank you. Is there anyone else who wishes to testify on, for, or against HB 414? If not, the chair recognizes Representative Collier to close.
Thank you, Mr. Chairman. You know, money and greed, money combined with greed is a dangerous thing. This bill does not call for a specific number of caseload. It gives the Texas Indigent Defense Commission, who is charged with making sure that we uphold our Sixth Amendment obligations, the ability to set those numbers. And it's fluid. It depends on what the circumstances are. In theory, they could propose a formula that accounts for the differences between urban and rural communities, as well as the availability of court appointments. And we heard one witness say, if we find out, if the commission sees that there's a lack, then maybe they could provide incentives. It could be a carrot and more. So the gravity of noncompliance is there. We could be out of line with our federal obligations. So that's why we have these rules and we have this bill before you to make sure that we do provide the opportunity for those who are faced with a criminal charge that has confinement as one of the penalties. They have access and the opportunity to have an effective assistance of counsel. And with that, I ask for your favorable consideration and that you pass this bill out of this committee, and I'm open for questions.
Thank you, Representative Collier. Members, do we have any questions for Representative Collier? Vice Chair Cook.
Admittedly, kind of an odd question, but why did this bill not get a hearing last session?
You mean when I was chair?
Yes, ma'am.
I think I had too many cases. I had too many cases. Oh my God. Why'd you make me say that?
No pun intended.
I literally had too many cases.
We did, because we went to like 2 in the morning.
I know. And see, and that was innocent. You see, I mean, I don't believe attorneys are doing this just out of greed all the time. You know, it's innocent. It can be innocent, and you can always mean well. But you got to be able to say, no, stop, I can't take any more.
Can't file any more bills.
I can't file any more bills. But yes, that's right. Sorry. But that was a good question. There you go.
Thank you, Vice Chair Cook. Yeah, Chairman Darby.
I guess just following up, judges are the ones that appoint these attorneys. And so somebody in Bowie County appointed a guy 640 times. I mean, where's the judicial oversight? I mean, it seems like one of the factors judges should consider would be the caseload of the attorney that they're appointing. And these judges have universally, seems like, ignored the cases in which they've appointed them in a single year.
Right.
I mean, it's just staggering. In Dallas County, you know, over 1,000 cases to one attorney.
In 1 year.
In 1 year.
Yeah, so there is, you know, you're supposed to do the wheel after if you're not using the public defender's office, but The problem is that if the next person on the wheel, the judge has the discretion to go to the person after that or somebody else. And this,
I'm just curious, would the existing caseload of that attorney being considered for appointment become relevant at any time to the judge?
I don't know that answer because I don't know how they're doing it in Bowie County. I don't know, but I can look into that if you'd like.
Well, I mean, here we are trying to cover a practice, if you will, putting constraints on that practice when judges.
Guidelines, but we're putting guidelines,
Yeah,
yes.
blinders, if you will. I mean, the judges themselves have the ability to
Fair
do
enough.
this by not appointing those attorneys more than the commission caseload.
Well, you know, cronyism exists too, and I'm not saying that's happening. I don't know what's going on in Bowie County, but you know that can be an issue too. It's like you get your friends' cases. I mean, it could be a whole bunch of reasons, but we just need to put some metrics in place that would help safeguard that process.
Okay, thank you.
Mm-hmm.
Thank you, Chairman Darby. Thank you, Representative Collier.
All right, thank you.
If do we have any? No, okay. Do you have no questions? Then, if there's any objections to HR 414 being left pending, hearing none. HB. Sorry. If there's no objection for HB 414 being left pending, then HB 414 will be left pending. Thank you. The chair lays out HB 352 and recognizes Representative Jessica Gonzalez to present her bill. Thank you so much for your patience.
Thank you. Members, thank you for giving me the opportunity to lay out House Bill 352. In the past decade, Texas has taken extraordinary steps to prevent wrongful convictions so that not one more innocent person loses years of their life behind bars. I am proud to reintroduce House Bill 352 for the third time, which has passed out unanimously through this committee twice, and last session got voted out on the House floor with over 2/3 majority. This bill amends the Code of Criminal Procedure to require a court to appoint an attorney to represent indigent defendants with a potentially meritorious habeas corpus claim. What's important about HB 352 is that it requires an appointed counsel to investigate the claim in ways that the state's conviction integrity unit or defendants can't, such as reviewing defense files, questioning witnesses, re-examining evidence, and so on. That's how we can find out if someone has a claim, if their claim has merit. This bill also, it clarifies what a meritorious claim might be. Current statute only allows counsel to be appointed if the defendant is not guilty, is guilty of a lesser offense, or was sentenced under unconstitutional law. This bill would add that a violation of the defendant's constitutional rights is also a reason to appoint counsel. I'm available to answer any questions the committee has, and I know we have a witness here from the Dallas District Attorney's Office. So if there are no questions as of now, I reserve my right to close.
Thank you, Representative Gonzalez. Members, do we have any questions for Representative Gonzalez?
Thank you.
Thank you so much. We'll proceed with testimony. The chair calls Brittany Dunn. Thank you for being here.
Thank you. Thank you, Mr. Chairman and members. My name is Brittany Dunn, and I am a prosecutor at the Dallas County District Attorney's Office. Specifically, I'm the Deputy Chief of the Conviction Integrity Unit there. As a Dallas County prosecutor, I'm so sorry, and I am testifying in support of House Bill 352. As a Dallas County prosecutor, having been assigned to the Conviction Integrity Unit, or the CIU, and having worked on the many cases that we've handled and people have submitted to us, I've had the unique opportunity to evaluate these hundreds of cases that are submitted to us for actual innocence and wrongful conviction. Every so often, when we get these claims, we get a case that after reviewing the state's files and the relevant litigation history, we believe the pro se convicted person may have a meritorious claim, but we are unable to fully evaluate whether that claim actually has merit. This is because convicted persons don't have counsel, and therefore we're unable to access certain information that was known to the defense at the time. I'll give you an example. Sometimes there are claims that we get where the defendant is claiming that there has been prosecutorial misconduct or the defense didn't know certain things from the prosecutor. And so, as you can imagine, we get these claims fairly often. But if we are just the only ones investigating this, we do not have access to the defense trial file. So we are not in a position to be able to determine what the defense knew at the time of trial and what was actually turned over. So this, as you can imagine, will cause complications in when we're trying to evaluate the merit of a claim. So another reason that we think it's important is also it's much more difficult to communicate with a pro se inmate, as you would imagine, especially when we're trying to explain the legal nuances that goes into these types of claims. We're also not in a position to offer legal advice or counseling to a pro se applicant. Habeas law is unforgiving and it's complicated. And so when it comes to litigating claims, persons with potentially meritorious claims need competent habeas counsel. They need competent post-conviction counsel. This will help navigate the intricacies of habeas law, and that helps us do a collaborative investigation of their case. Now, the differences that you're going to see come from the reasons that we want to change this to clarify and expand the criteria for mandatory court appointments in certain habeas cases, but we do want to also maintain the original core scope, which is very narrow of the current legislation, which currently it has to be that the defendant must be indigent, and two, the mandatory appointed counsel must be requested by the state in certain situations. Now, currently, the statute only allows the state to request an appointment of an attorney to file an application for writ of habeas corpus for a defendant if the state believes that the defendant is not guilty, is guilty of only a lesser offense, or was convicted or sentenced under a law that has now been found unconstitutional. These proposed changes would allow the state to request the appointment of an attorney, not just to file, but to also investigate and or file a writ of habeas corpus for the defendant if the state believes that the indigent defendant is or may be actually innocent, is or may be guilty only of a lesser offense, was or may have been convicted or sentenced under a law that has been found unconstitutional, or was or may have been convicted or sentenced in violation of the state or U.S. Constitution. So you see the may have coming into play when we are talking about adding the investigation piece of appointing a counsel. Now, this last type of claim regarding the U.S. Constitution violation, it would encompass a broader range of laws under which persons have been wrongfully convicted could seek relief. So it's important to note that this doesn't in any way limit the court's power to appoint an attorney to represent the defendant. The changes would help indigent defendants have adequate access to the legal system post-conviction, but it would greatly aid the conviction integrity units such as ours to properly investigate meritorious claims. So for these reasons, I encourage you to approve House Bill 352.
Thank you, Ms. Dunn. Members, do we have any questions for Ms. Dunn? No. Thank you very much for being here.
Sure.
The chair calls Benjamin Wolf.
Good afternoon. Again, my name is Benjamin Wolf. I'm the director of the Office of Capital and Forensic Writs, and I'm testifying on this bill. I'll keep my remarks on this bill brief. Our office is the post-conviction public defender for the state of Texas. We handle mainly death penalty post-conviction cases, but also handle a limited number of cases, non-capital cases that are referred to us by the Forensic Science Commission involving questionable forensic science. There's CIUs across the state of Texas, but they're doing great work at uncovering wrongful convictions. But apart from the narrow authority which allows us to handle a very small set of non-capital cases of potential wrongful convictions, there's not a good mechanism for the appointment of defense counsel in these cases. And the current statute, and sometimes you need a defense attorney. either the CIUs can only do so much. There's CIUs across the state of Texas who are looking into these cases, and they need a defense attorney to talk to a client, advise their client, find out what happened. That's something that CIUs are ill-equipped to do, and this bill would revise the statute so that enabling the CIUs or district attorneys that are reviewing these cases have questions about these cases can get a lawyer to work collaboratively with on these cases without having to represent that someone is actually innocent, just that someone may be innocent, may be convicted or sentenced unconstitutionally. Thank you. Happy to answer any questions.
Thank you, Mr. Wolf. Members, do we have any questions from Mr. Wolf? No? Okay, thank you very much.
Thank you.
The chair calls Scott Eilers. Thank you for being here, sir. Did I say that correctly?
Eilers.
Eilers, okay, sorry about that.
That's all right. Thanks for having me. Good afternoon, Chairman Bojani and members. My name is Scott Eilers. I'm the Director of Public Defense Improvement for the Texas Indigent Defense Commission, and I'm here to testify on HB 352 as a resource witness. HB 352 contains one of the legislative proposals or legislative recommendations that was approved by the Texas Indigent Defense Commission's governing board. TIDC is directed by the legislature in statute to come to you every legislative session with recommendations on ways to improve Texas's indigent defense system, and this was one of the bills that our board is recommending to you. In terms of the process, I told you all this last week. We have a legislative stakeholder work group that we bring all stakeholders together. We meet in subcommittees, and we come up with consensus items that are then go through our policy monitoring, or excuse me, our policies and standards committee, and then that goes to the full board, and the full board on items that are where there is consensus will recommend to the legislature. Regarding HB 352, I thought the representative from the Dallas District Attorney's Office did a great job of laying out the bill. This was their idea, and they came to us with this proposal. Once again, it would clarify when a convicting court may appoint an attorney to represent an indigent defendant on a writ of habeas corpus in very limited circumstances. That appointment of counsel would occur only after a prosecutor tells the court about one of the errors that potentially occurred. As was noted, the statutory changes are being proposed because prosecutors and judges do not definitively know that a condition for relief has been met, but a defendant may nonetheless need counsel to investigate that potential claim for habeas relief. I'm happy to answer any other questions y'all have. There were also a number of issues that arose in the last bill that y'all were talking about, HB 414.
You're testifying on this bill, right?
Got it. Okay.
Sorry. Members, do we have any questions for the witness?
Do you have a copy of the bill with you?
Yes. Yes, Representative.
So in section B, should that be under a petition for writ of habeas corpus as opposed to a writ of habeas corpus? I mean, because basically the district attorney's office would bring this matter to the attention of a court, and the court would appoint an attorney. Is that the procedure that we're attempting to accomplish?
Yes. Representative committee court that are eligible and defendant has. I don't know that a petition. I don't know that it really matters as I read it.
Well, a writ is a directive. A petition is a request.
That is correct.
I mean, so if a court issues a writ, then that's commanding something. If a district attorney's office, I would think they would ask for permission. They wouldn't issue a writ. So just a comment.
I think that clarifying amendment would work, and I'll leave it to the representative, but I think that would be fine.
Thank you.
Thank you, Vice Chair Cook. Members, do we have any other questions? Thank you very much.
Okay, thank you.
The chair calls Charlie Malouf. Good afternoon. Thank you for being here.
My name is Charlie Malouf, and I am representing myself, and I'm also the acting vice president representing Texas Cure, and we are for House Bill 352.
Thank you very much.
Last session, I testified individually regarding issues with the 1107 writ of habeas corpus process. While incarcerated, I assisted multiple inmates who were denied their Article 1107 writs of habeas corpus without review. Even with due process grounds such as ineffective assistance of counsel and exculpatory grounds based on evidence obtained after trial, a significant number of them are either actually innocent or their punishment didn't fit the crime. In addition, most suffer or suffered from ongoing multiple denials of parole, even though they were or are model prisoners and truly have demonstrated remorse in their ability to become productive members of society upon release. According to my open records request response from the court administrator for the Court of Criminal Appeals in 2019, there were 3,686 Article 1107 writs filed. Out of the 3,686 filed, 3,427 were accepted by the court, but only 147 were granted review, but 96% denied without review. This is a normal percentage denials, as I was told. I cannot believe this number has gotten any less over time. Texas has been and still leads the nation in exonerations of wrongfully convicted. Over the last 4.5 years, I've worked as a contract paralegal for multiple attorneys involved in prisoner cases. As an advocate, I, through the organizations, have put many a prisoner in touch with attorneys to take their appeals, but as most cannot afford an attorney, and unless it's a wrongful death, almost all attorneys will not do a pro bono prisoner case. The inmates are left hopeless, finding help, and try to do things on themselves. In my research of the thousands of case law, the most common denominator in the written pro se appellate denials is deficient pleadings. Inmates in the TDCJ are routinely denied access to the law library. When they do get to go, the law books are 5 to 7 years antiquated. TDCJ is now handing out tablets, and it's my understanding these tablets have LexisNexis on them. However, there is no training on the program for inmates, and to compound this with the fact that a significant number of TDCJ prisoners are illiterate or only have a 6th to 8th grade mental faculties in a programming subject matter currently being addressed in other bills and corrections. How on earth is an inmate supposed to make a proper pleading with these extreme limitations? This bill allows fundamental fairness in the interest of justice, and we respectfully request your favorable consideration to move it.
Thank you very much. Members, do we have any questions for the witness? No. Thank you for your time. Is there anybody else who wishes to testify on, for, or against HB 352? If not, the chair recognizes Representative Gonzalez to come to close on her bill.
Thank you, members. And I wanted to address your questions. I don't think I heard it all the way.
Sure. Yeah. So when I think of a writ of habeas corpus, I think of a writ being issued by court, and I think of a petition as how you ask for that relief that's set forth. And so I just think it probably makes sense to say, when the district attorney's office has filed a petition for writ of habeas corpus where they're seeking that relief. That's the only clarification I was making.
Okay. Because I think that's just how it's referred to. It's just like a writ of habeas corpus. And then when you file an application for a writ of habeas corpus.
What I'm wanting to make sure, a lot of times a writ of habeas corpus, sometimes it will free an individual. And so I want to make sure that that's not what is happening here. I mean, I think it's clearly based on the district attorney's testimony today. She's setting up a procedure where they're asking the court to appoint indigent counsel under 1.051, and that would be in the form of a petition for writ of habeas corpus, not a writ for habeas corpus. So a writ gets issued at the direction of a judge by a district clerk, and the petition is something that would be filed by the district attorney's office. So I just want to make sure that it's clear that it's a seeking permission, not issuing an order. That
Okay.
makes sense.
All right.
Chairman Darby.
Just to follow up on that, I do think the language is confusing. Your language has under a writ of habeas corpus, which is the process after the investigation has been made by the attorney into the meritorious claims for a writ, and that was presented to the court. Your language says, has under a writ of habeas corpus. Shouldn't it say at the least believes that under a petition for a writ of habeas corpus, a potentially meritorious claim? I mean, seems to me like you're before even the filing of a petition, certainly before the issuance of a writ. The state has a question that they may be eligible for relief, and we want an attorney appointed to investigate that eligibility. And if it's found meritorious, then the attorney would ask for a writ of habeas corpus. Isn't that kind of the procedure?
Yeah, I mean, I think right here is this, because the article is referring to is that 1.051 is referring to a right to be represented by counsel.
Yeah.
And so this is saying, I mean, I guess if you,
Well,
what it's saying is that
you're
if somebody,
taking out language that I think was clear that says, if at any time the state represents to the convicting court that an eligible indigent defense under Article 1.051, and then you struck who was sentenced or had a sentence suspended is not guilty, or is guilty only of a lesser offense, or was convicted or sentenced under a law that was subsequently found unconstitutional by the Court of Criminal Appeals of the United States Supreme Court, the court shall appoint an attorney. So what I think you're trying to do is say, if the state believes that there may be a meritorious claim under a potential petition for a writ of habeas corpus,
that's how I read it.
Then this is what you're trying to do. I mean, I just don't think that, to me, it doesn't properly describe the procedure in which you ultimately arrive at the relief you're requesting, which is a petition, which is a writ of habeas corpus.
it would be an application for a writ of habeas corpus. It's an application.
Relief
that,
application or
that you
petition,
file
or
for writ.
simply believes.
But I mean, but here writ is not referred to in the same way that you're thinking, because that's just, it's like a term of art. Writ of habeas
Granting
corpus.
a writ of habeas corpus would be.
It means bring the body before, I mean, is generally what it means. And so a writ is a command, an application or a request is asking for permission. And judges do that, prosecutors and plaintiff's attorneys ask for, in the form of a petition.
Not sure what the process, but we have a lot of people here who are probably experts in this arena as well, that if they wish to testify.
We'll talk about the language more. I mean, I want to make sure it's not confusing. I mean, I don't think it's ever been brought up. I mean, this is my third session carrying that. Nobody's ever brought that up before, but I want to make sure that people aren't confused, and so we'll work on see if we can change that language. Are there
any other questions? Representative?
No other questions.
Okay. Where was I? Okay. Ask for your favorable support on this bill. It does have strong bipartisan support. It's important that people aren't behind bars if they don't deserve to be behind bars, and they have legal representation if they can't afford it. And it also does not have a fiscal note, even though people are getting these appointments, and so that's always a good thing. But if there are no more questions, I close.
Thank you, Representative Gonzalez. Is there any objection to leaving HB 352 pending? Hearing none, HB 352 is left pending. Thank you. The chair lays out HB 779 and recognizes Representative Vasood to explain his bill. Thank you for your patience.
Thank you, Mr. Chairman. Mr. Chairman, members of the committee, the opportunity to lay out House Bill 779. Current law allows statutory county courts to issue search warrants, but based on the absence of the term statutory county court in Article 1801D and 180215B of the Code of Criminal Procedure, it's unclear if they can issue warrants for cellular, telephone, or other wireless communication devices or subsequent search warrants. So House Bill 779 clarifies the law to expressly allow statutory county courts to issue subsequent search warrants and warrants for cellular, telephone, or other wireless communication devices. Primary reason to do that, statutory county court of law judges are lawyers, just like district judges, and by allowing them to be able to issue these subsequent warrants and cell phone warrants, it frees up the time of district court judges to be able to focus on other matters if they need to, allows for more judicial economy, and I think helps our judiciary function more efficiently in the state of Texas. And there's no questions I reserved. I don't think there's anybody that's going to testify on for or against this bill, but I'm happy to take any questions from the committee.
Thank you, Vice Chair Vasood. Members, do you have any questions? Yeah, I don't see any witnesses here, but I can just, if there's anybody wishing to testify on, for, or against HB 779. Okay, yeah, please.
Mr. Chairman, members of the committee, it's a good bill, low-hanging fruit. Ask you for favorable consideration, send it to local consent. Thanks again.
Thank you, Vice Chair Vasood. Are there any objections to having HB 779 left pending? If not, then HB 779 is left pending. Thank you. The chair lays out HB 964 and recognizes Chairman Jatan to explain his bill.
Thank you, Chairman Majani and members. I'm here to lay out House Bill 964, which expands the sex offender registry list to include educators who have been convicted or adjudicated of having improper relationship with a student. An improper relationship between an educator and a student is defined in Section 21.12 of the Texas Penal Code as an employee of public or private, primary or secondary school who engages in sexual conduct, sexual intercourse, or deviant sexual intercourse with a student. We place a special trust in our educators to provide a safe and fostering environment for our children to learn and grow. When that trust is broken, the educators should need to register with the sex offender list and with the more than 1,000 school districts that are hiring educators. This ensures the educator is not able to make their way into another classroom anywhere in the state. The Texas Sex Offender Registration Program is a sex offender registration and public notification law designed to protect the public from sex offenders. Adults who have served as teachers and are entrusted by children and families who then go to violate this trust and engage in sexually exploitative behavior with a student should be prosecuted accordingly. If convicted, this public should be notified of this person's past actions relating to children in order to ensure the safety of children. And so at this time, I'm happy to answer any questions. Otherwise, I reserve the right to close.
Thank you, Chairman Jatan. Members, do we have any questions of Chairman Jatan? No? Okay. All right. Thanks so much. We'll move to testimony. The chair calls Jordan Johnson. Sorry. Thank you for being here.
Thank you. Hello, Chairman and members. My name is Jordan Johnson, and I am testifying for this bill. I'm representing myself and the thousands of voices that cannot be here today within the children who have been impacted by this. Essentially, what this bill is covering is the topic of grooming within my field. I am an advocate for survivors of human trafficking within the Safe Alliance, which is based here in Travis County. Basically, what grooming is a psychological manipulation of a vulnerable target with the means of future exploitation. It's sinister. The impacts of it are life-lasting, and it can potentially set up survivors for further harm and exploitation within their life. Every day I sit down with young children explaining how they're struggling to understand what a sex offender is, what a child predator is, and the impact that this has on their life. It can take them well into their adult years to finally accept the fact that somebody who gained their trust, who breached those boundaries of safety and responsibility as a safe adult, who manipulated them into potentially and usually doing acts that they would never consent to, especially based on the fact that children can't consent until they're 18. Grooming is probably one of the most sinister forms of harm that you can do to a survivor because it takes so long to unprogram. It takes so long for survivors to process the harm that has been done to them, and it's even harder for them to learn how to trust again. I think it's our responsibility as a state of Texas to make sure we do whatever we can to protect children. I think as adults, as parents, as teachers, and as even older siblings, we should do everything we can to protect the innocence and the youth of kids to set them up for success in the future. So I very much ask that you choose that responsibility with me as well. Thank you.
Thank you, Ms. Johnson. Just to clarify, this bill impacts so many people for procedural purposes. You're speaking on your own behalf.
Yes.
Right. Okay. Thank you. Members, do we have any questions of Ms. Johnson? Okay. Thank you very much. The chair calls Rhonda Kukundal. I don't know if I said that properly.
Hi, Chairman Bajani, committee members. Thank you so much. My name is Rhonda Kirkendall. I chair the Fort Bend County District Attorney's Human Trafficking Team. I am also on the State Human Trafficking Survivor Leader Council, and I work as the Anti-Child Trafficking Consultant to Texas CASA. I'm here today on behalf of the Fort Bend County District Attorney's Office in support of House Bill 964. As we know right now, where it currently stands, it's a second-degree felony, and perpetrators convicted can face a fine of up to $10,000. But one thing that is missing is a registration on the sex offender registry. And if you look back on it, the TEA, the most recent numbers that we came out with were from 2017, where they found that 686 teachers in Texas have lost their licenses following an allegation of impropriety with the student. 8 of those 10 that surrendered their license, they did it on their own in lieu of disciplinary proceedings. Teachers who surrender their license, though, can still teach in charter schools and private schools. That number from the TEA also said that open investigations increased by 42%. And this number is a 249% increase from a decade ago. So currently, our prosecutors at the Fort Bend County District Attorney's Office are having to charge with different charges that actually have a stipulation for registration on the sex offender registry. We have had several cases in Fort Bend County with improper relationship between an educator and a student. And this bill was filed in order to prevent what's called pass the trash, where educators can go from school district to school district. Because whether a perpetrator receives deferred adjudication, probation, or is convicted, there can be a requirement to register on the sex offender registry. It is our hope that House Bill 964 will be voted on favorably. Thank you.
Thank you very much. Members, do we have any questions of the witness? No? Thank you so much for being here. Is there anyone else who wishes to testify on, for, or against HB 964? If not, the chair recognizes Chairman Jaton to close on his bill.
Thank you, Chairman. Thank you for those that testified and for you listening to this bill today. If there's no other questions, I ask for your favorable consideration and close.
Members, do we have any questions? No? Okay. Thank you very much.
Thank you.
Thank you. Is there any objection for HB 964 to be left pending? If not, then HB 964 is left pending. Thank you. The chair lays out HB 1104 and recognizes Representative Cunningham to explain his bill. Thank you for your patience.
Good afternoon, Chairman Bajani and members. I want to thank you for allowing me to present HB 1104. The bill was brought to me by my Assistant Chief, Chief of Police in Humble. Current law enforcement evidence rooms around the state are required to hold on to evidence during a court case in which the defendant has already pleaded guilty and relinquished all rights and appeals and to an appeals process. This has led to an increase in evidence/property in these rooms, which has resulted in evidence rooms exceeding capacity and law enforcement agencies needing needing to build temporary pods and to hold rooms. Let me stop for a moment. I'm not as young as I used to be.
Take your time.
Oh, yes, better. Expending unnecessary costs. Years will go by before destruction orders are reviewed and requires research to be done in the case that would have been available at a time of a plea of guilty. HB 1104 allows the defendant who has entered into a plea of guilty or no contest, acting with counsel, to waive their rights to preservation of evidence in a case where that is applicable. The bill creates a format for a waiver, which is currently used in Montgomery County and has been for several years now. All parties in the case, prosecution, the judge, the defendants, and his or her counsel are required to be present at the time of the plea. This allows for a destruction order to be done at that time. If a defendant pleads guilty and decides to waive their right to preservation of evidence, the bill allows 4 possible options. The evidence of the property can be returned to the rightful owner. The evidence of the property can be used by law enforcement. The property can be sold by law enforcement, or it can be destroyed. Finally, on page 2 of the bill, any evidence known to contain biological material must be preserved until the defendant dies, completes their sentence, or the term of community supervision or is released on parole. The defendant, their counsel, and the court still have 90 days after signing the waiver to object to the planned destruction of that biological evidence. And with that, Mr. Chairman, committee members, I want to thank you. If you have any questions, I do have my Assistant Chief of Police here as a witness and well as a resource from DPS Crime Lab Division. And I want to reserve the right to close.
Thank you, Representative Cunningham. Members, do we have any questions from Representative Cunningham? Thank you. We'll proceed with testimony. The chair calls Paige Williams.
I think she may have stepped out.
The chair calls Sarah Wilson. Thank you for being here.
Good afternoon. Good afternoon. My name is Sarah Wilson. I'm testifying for the bill. I have over 23 years of experience in the field of forensics, crime scene, and evidence preservation. I'm also a board member of Texas Association.
Are you testifying on behalf of someone and yourself?
Yes, I'm
But do you want to say that?
Texas Association of Property and Evidence Inventory Technicians. So I was getting right there.
Oh, thank you very much.
Yes, sir. Okay. So I'm also a board member of TAPE IT. TAPE IT represents, trains, and educates over 500 police agencies statewide. There are many other states who emulate our practices. TAPE IT's purpose is to promote professional education, laws, rules, and guidelines for upholding the integrity of property and evidence, maintaining chain of custody, and the disposal of property and evidence. Our goals include educating and training, a change in the laws for a clear and simple interpretation, and obtaining agreement with our district attorney's office and local law enforcement agencies on the disposal and return of property and evidence to their rightful owners. Our goals also include establishing time limits for courts to notify agencies of the disposition of property and evidence. This bill, 1104, clearly connects. This bill is relating to a waiver of the preservation of evidence and the return of a seized weapon in a criminal case. This bill will streamline the process and disposition of property related to criminal cases. This process will not shift the responsibility for a decision to be made at a later time, but render the decision-making to those who know the most about the court case. This will allow the judge, counsel, and defendant to come to a decision while the case is in front of the courts. Currently, law enforcement agencies across the state of Texas have property and evidence rooms that are full. They have reached maximum capacity, and many law enforcement agencies are having to build larger buildings and larger storage facilities to hold all of this property. Much of the property and evidence being held are from court cases which are complete and could have been disposed of years earlier. What this bill is not. This is not a reversal of recent policies. This bill does not destroy sexual assault kits. This bill clearly carves out DNA evidence and leaves it currently as is. Also, this bill as written does not and will not alter 3843 and 50. It simply follows them. This bill is not changing what property and evidence room across the state are currently doing. What it does is expedite the process. This bill will help streamline the process of police-held property and evidence. Thank you for your time.
Thank you, Ms. Wilson. Members, do you have any questions for Ms. Wilson? No. Thank you very much. Thank you for your time. Chair calls Edwin Walker. Thank you for being here today.
Thank you. Good afternoon, members of the committee. My name is Edwin Walker. I'm a criminal defense attorney. I've been a criminal defense attorney for 30 years. For the last 10 years, I've been focusing mostly on self-defense cases and weapons cases. And I am here to speak against this bill. And the reason I'm against it is with regard to its specific inclusion of firearms, in which previously firearms have not been included in the property waiver of this. And the reason that I do not believe firearms should be included in this is the committee would probably be very surprised at how hostile the police and prosecutors can be to some legitimate self-defense cases, especially when the claim of self-defense is made under Texas Penal Code 9.04, where a person is specifically allowed and justified and lawful in producing a weapon as a deterrent in a use of force situation that has not yet become a use of deadly force situation. This leads to many otherwise innocent people being charged with the crimes of disorderly conduct, deadly conduct, or aggravated assault. Many times a prosecutor, once a charge is filed, even while recognizing that there is a meritorious self-defense case, will attempt to negotiate a plea bargain rather than dismiss the case. Now, sometimes this is because of their inherent recalcitrance against dismissing cases. Sometimes it's office policy. Sometimes it is simply just an attempt to get the person to take a plea bargain. Currently, the disposition of the weapon is part of this negotiation. If this bill is passed, this will cause, as a practical effect, this will cause the inclusion of firearms to be included on the pre-printed waivers of objecting to the destruction of evidence that already exist. And this will give the state an unfair advantage in negotiating these cases because, as a practical matter, neither the prosecutors or the courts like to see their pre-printed forms scratched out and drawn on. They like for them to be signed nice and clean. And so if this waiver is included in there, it's going to be very, very difficult to negotiate it out. Now, why would you want to negotiate it out? Well, because in many of these cases, a lot of defendants who do have legitimate self-defense claims, but the prosecutors refuse to dismiss the case, they will offer something very favorable, like a 6-month deferred adjudication, something to that effect. And the defendants usually will take it either because of fear of going to trial, either because they don't have the money to go to trial, or either because of just the convenience of not going to trial. This will result in many people who take these plea bargains automatically losing this property, and we do not believe that that is a proper outcome. We believe that it should still be left to the parties to specifically negotiate the release of that firearm, which we believe these pre-printed forms that will come into fruition will prevent. And so we're urging that this bill not be adopted.
Thank you, Mr. Walker. Members, do we have any questions for Mr. Walker?
Thank you.
Thank you for your time. The Chair calls Allen Place.
Mr. Chairman and members, my name is Alan Place. I'm here on behalf of Texas Criminal Defense Lawyers Associations, and as written, we are opposed to the bill, and let me be as brief as I can, explain to you why. The preservation of evidence basically is the very basis of habeas corpus work. Without the ability of having evidence preserved, a person could never really come back and challenge. The most probably famous case in Texas that led to the Michael Morton Act 10 years ago, basically the state and the police did preserve a bandana basically that was later tested, and the DNA on it showed that not only did Mr. Morton not kill his wife, they actually led to the evidence that acquitted, basically acquitted him at a later time and convicted another person. That is our primary concern, but there's also a secondary concern that I think would be an unintended consequence of this bill. If you were to have such a waiver that could potentially be used during a plea negotiation or when the case is pending, that puts, in our opinion, a very chilling effect on the person that's accused of a crime. Just to give you a death penalty case, for example, when you have death penalty or life without parole, you have two choices. And certainly if they were to go to the attorney for the defendant and basically indicate that they were seeking this kind of waiver, basically, and we want that, and we'll give a lesser, deal basically at that particular point. If you have your life hanging in the balance, you're going to listen to that offer whether you do it or not. It's certainly going to get your attention. So that is a concern. And so if this bill or anything similar were to move forward, at the very least, we would want to have something in there that basically states that this kind of waiver could never be used in any sort of plea negotiation and or could use it in any sort of way during the actual plea process. We think that would I think it's such a broad area that it pretty much, in our opinion, just violates traditional notions of fair play, basically, to have that kind of pressure put upon it. Now, I realize as the bill's written, it's intended to be done at a later time. But if this becomes a state statute, there's nothing that's going to discourage, the state from being able to use it during plea negotiations, and we think that's just inappropriate.
Thank you. Members, do we have any questions from Mr. Place?
So do you have suggested language on what you're...
I talked to Representative Cunningham yesterday, and this is kind of one of those deals that you kind of need to think through and sleep on. And so, yes, we haven't got there yet, but if the committee were to want to try, to do this in some sort of way, I think if it addresses that it is something that cannot be held in a plea bargain or used in some sort of plea bargain, that's our biggest concern. The secondary concern, of course, is whether or not this evidence could ever be used at some point, for a writ, and it would be other items that could be tested. It wouldn't just be in our opinion, the biological samples. It could be other items that could be tested for DNA at some point in time. And so yeah, I think there's a way there, but it's an awkward fit in all candor.
I would appreciate you continuing to work with Representative Cunningham on it. Thank you.
Thank you, Mr. Place. Thank you, members. Chair calls Dan Zientek.
Hello, Chairman Chami and members. I am Dan Zientek. I am speaking for the bill. I'm representing myself as an individual, also the Humboldt Police Department as the Assistant Chief there.
Thanks for being here.
So, good afternoon. I've been in law enforcement 31 years. I serve as Assistant Chief of Humboldt. I'm also on the board for TAPIT, which you heard about earlier. This bill is to expedite the disposition of property related to criminal cases. Procedures that are laid out in this bill are currently in practice in Montgomery County and have been for years. At the close of a case, after a defendant pleads guilty, waives their right to appeal, the defendant, their counsel, and the judge signs this disposition That is what this is for, to expedite the destruction of evidence. What currently is going on in many counties is that years later, even speaking in Humble, 5 to 10 years after someone has been arrested for DWI or for drugs, hopefully changed their life and moved on to a better way of life, we still have their evidence 10 years later. We have to petition to the court. The people that were involved in the case, the prosecution, the defense, and the judge most likely in that court are no longer there. We have to do research on this case to come to the same conclusion of destruction that we would have come to while everyone was present. Currently in Humble, we're having to expand our property room at close to the cost of $1 million to keep track of evidence that has been there 10 plus years that should have been disposed of years ago. This bill ensures the property is returned to the rightful owner. Currently, if you have property in a case and you were a victim of a crime, we're keeping that for 5 to 10 years until we get some type of order of release. Again, this expedites that process. Nothing has really changed. It's just bringing it forward. So to address some of the concerns that have been brought up before you, I've heard in a couple of different testimonies about the Michael Morton Act and brought up on this bill too. To speak about Michael Morton, he never pled guilty. He always claimed his innocence. He always had his right to appeal. He never gave that up. It is because of that that evidence was kept. And thank God he was released many years later because of that. That is not this. This is a defendant that has pled guilty, that has given up all rights to appeal. He is meeting with his defense counsel and with the judge that has all the information related to that case at that time to decide the disposition. It is not an order that commands it. It is one that a defense attorney can refute. There is also a time frame later that it can be brought back before the court for whatever reason. The mention of guns. Guns are being destroyed today from destruction orders. This is nothing new in destruction of guns. We have the ability to release to rightful owners, to auction, to use at a department, or to destroy as related to evidence, including firearms. This does nothing but expedite that process. We have had concerns about biological. The legislation took care of that by providing funds for all police departments to send off our sexual assault kits, and it's done an amazing job. Those are already being tested. It's already in CODIS. Again, I know I reflect back to the same statement. This is just expediting what we're already doing with the proper people being present that can speak knowledgeably to the case.
Thank you, Officer Zantek. Chair recognizes Chairman Moody that has joined us today, right now. Members, do you have any questions from Officer Zantek? Thank you so much for your testimony. Really appreciate it.
Oh, Mr. Giant?
Yes.
If I may, I don't know if appropriate or not. If not, I won't. I have a court order from Montgomery County that currently uses this procedure. If I can give that to y'all.
Sure, yeah. Thank you.
Thank you very much.
Thank you, Officer. Chair calls Brady Mills. Thank you for being here.
Good afternoon, Mr. Chairman, committee members. My name is Brady Mills. I'm the chief of the Texas Department of Public Safety's Crime Laboratory Division. I'm speaking on the bill as a resource witness. I could happy to answer any questions regarding how we process evidence, what we keep in our laboratories before we give the bulk evidence back. We do work, about 85% of our work are for local investigators. So the bulk evidence that we process in our laboratories are returned to the local entities for storage. DNA was discussed a little bit. We retain DNA cuttings from all the cases that we work in our laboratory freezers indefinitely. Toxicology was mentioned as well. That is something that is a stressor for us as an organization because we do have to keep the toxicology tubes for all the cases we work for the Texas Highway Patrol. We currently have 30,000 of those tubes stored in a bio warehouse in the Houston area. And the forensic value of those are depleting, and it depletes over time. Even though we do keep those refrigerated, it depletes over time. But there is a challenge for us to go through the disposition process to get those destroyed. But if there's any other questions that the committee has, I'd be happy to answer those.
Thank you, Mr. Mills. Members, do we have any questions of Mr. Mills? Thank you for your testimony.
Thank you.
Is there anyone who wishes to testify on, for, or against HB 1104? If not, the chair recognizes Representative Cunningham to close on his bill.
Thank you, Chairman Bajani and members, for allowing me this opportunity to present this bill. Before the committee leaves this bill and pending, I just want to reiterate just a few things. What this bill is not. The bill is not a plea agreement. The waiver of preservation is done after the defendant has already pleaded guilty. He is in the presence of not only the attorney and the judge and the district attorney, but his attorney also. And then that's when this waiver is presented. So it's not used as a negotiating tool. I will be working with the lawyer on the committee sub, but I would already say that this bill is already being done. We got 254 counties. There's one county that's already doing it, Montgomery County, and have been doing it for several years, 4 years as a matter of fact. So I want to go ahead and just say, if you would, I would appreciate a fair hearing, moving on to the committee and hopefully to the calendars committee. And with that, I'll close. Thank you.
Thank you, Representative Cunningham. Members, do we have any questions? No? Okay, thank you, Representative Cunningham.
All right, thank you.
If there's no, is there any objection for having HB 1104 to be left pending? If not, seeing hearing none, HB 1104 is left pending. The chair lays out HB 908 and recognizes Chairman Moody to explain his bill. The chair also offers a committee substitute.
Thank you. Thank you, Mr. Chairman. Members, House Bill 908 is a bill about fairness in discovery and zealous representation in some of our most difficult criminal cases. Right now, when allegations of sexual crimes are made involving children, the child making the accusation is often the subject of a forensic interview at a child advocacy center. These interviews are recorded, and in many cases, they memorialize the central evidence in a case, since traditional forensic evidence like DNA isn't as common as you might assume in these cases. What's unusual, though, is how this evidence is handled. If there's a video or a photo or a statement or any other kind of evidence at all in any other case, the defense attorney gets a copy of it. That's how the defense evaluates a case and prepares for trial. And it makes good on the basic constitutional guarantees our system is built on. We don't have secret evidence in this country. For those videos, though, the defense isn't allowed a copy under the law. Practices vary from county to county, but generally they're allowed to make an appointment to watch the video in the presence of a representative of the state. The difference in an attorney's ability to dissect and prepare in that situation compared to having their own copy to review in their office, sometimes with an expert providing their feedback, is night and day. It results in poorer defense with less chance of getting to the truth and a greater chance of false convictions. And there's no good public policy reason for it. The substitute that is in front of you now creates a new procedure that allows the defense attorney to get a copy of the video with a court order. The court has to find that the defense has shown good cause for getting a copy, and the court can put additional orders in place that cover things like how a video has to be maintained, stored, and disseminated so that unsecure solutions like cloud storage can be prohibited. Once the defense attorney has a copy, they can't make another copy of it for anyone and aren't allowed to even show it to their client. Only the defense attorney, their investigator, their expert, their agent, or consulting legal counsel can view these videos and only in the physical presence of the defense attorney. And if the defense violates that restriction, it is a state jail felony. This bill puts strong guardrails in place with the involvement of the trial court and contains the strongest protections in law related to evidence security given the felony criminal penalty, which incidentally would also cost a lawyer their law license. So there's really no argument that these videos wouldn't be secure under the construct of the substitute. I'd put the ethics of the conscientious attorneys who protect the rights of the accused in our courtrooms up against any of those we see in law enforcement, prosecution, and child advocacy. And this bill will allow them to do their job effectively. I do know that this is an extremely sensitive subject, so I appreciate you taking the time to hear the bill. I'm prepared to answer any questions you have. I know there are witnesses here to testify as well, and if you see fit, I'd like to be recognized to close at the conclusion of testimony.
Thank you, Chairman Moody. Members, do we have any questions for Chairman Moody? Thank you. Thank you. We'll begin to proceed with testimony. Okay. Chair calls Julie Evans. Thank you for being here today.
Good afternoon. My name is Julie Evans, and I'm the CEO of Alliance for Children. We are Tarrant County's Children's Advocacy Center, and I'm testifying against House Bill 908. Alliance for Children provides children a safe place to tell their story to a professionally trained forensic interviewer. The interviewer memorializes the child's verbal and visual testimony for the purposes of civil and criminal investigations and prosecution. The interview is digitally recorded and is evidence. As a former forensic interviewer myself, I have sat with many children as they share the horrific details of violent physical and sexual assaults. As part of the prosecution, the forensic interview is made available to prosecutors and defense attorneys. Today, this evidence is handled in the same manner as child pornography. Copies are not made, nor are they electronically shared. Rather, giving the graphic nature of what is described and depicted, original evidence is viewed within the walls of the district attorney's office, and records reflect who accesses that evidence. Evidence describing sexual assault should continue to be safeguarded due to the graphic nature of details discussed. We asked children in the interview room to tell us everything they saw, heard, felt, smelled, tasted. Sometimes children will mimic the sexual sounds made by the perpetrator, moaning or breathing quickly. We have kids describe what genitals look like. Sometimes we even have them draw the genitals. We have them give specific detail about any sex toys or objects that the perpetrator uses. Some children describe feeling pain, like burning or stinging. Some children talk about the pain when defecating or peeing after the incidences they've experienced. They have also even described how things taste. Semen tastes like salty or sour, some children will tell us. A little girl said a penis tasted like skin. While this may sound harsh to your ears, these stories are being shared daily across Texas as part of an active criminal investigation. If House Bill 908 is passed, child victims of pornography will continue to have the videos and images of pornographic acts protected, as they should. Yet, if House Bill 908 is passed, child sexual assault victims will not have the same protection. Their story will walk out the doors of a secure building and lose the promise of confidentiality. While I understand that House Bill 908 provides some consequences should the forensic interview be mishandled, this would not undo the harm to that child. Not only does this create a way for the criminal justice system itself to harm a child, but it also puts future victims at risk and would call into question future children's ability to trust that their privacy and confidentiality would be protected. Children have a difficult time sharing the nightmares of sexual assault already. This puts an unnecessary and cruel level of risk for what appears to be the defense attorney's preferred schedule and ease. Throughout my 20-year experience in child protection, we have protected a child's confidentiality while allowing for due process within the criminal justice system. And I ask that you please continue to protect Texas children's with your vote against House Bill 908.
Thank you, Ms. Evans. Members, do we have any questions for Ms. Evans? No? Thank you very much for your testimony. Chair calls Justin Wood. Thank you for being here.
Thank you, Chair Bojani. Good afternoon. Thank you for having us. Good to see Representative Bowers and Representative Cook. I'm Justin Wood, General Counsel for Children's Advocacy Centers of Texas, and I'm here also testifying against House Bill 908. I'm here representing the Texas network of 70 children's advocacy centers that bring together teams of dedicated professionals through a coordinated and collaborative approach to serving child victims impacted by abuse throughout Texas. And as Julie said, 2 of which are in your districts and also represented in Dallas County. Within our CAC model, one of the critical services that we provide is the forensic interview. In fact, almost 45,000 forensic interviews were conducted at Texas CACs this past fiscal year. You've heard my colleague describe what that forensic interview looks like and how that works in our process. And historically, the credibility behind that forensic interview stands for itself. But the forensic interview recording is evidence. However, it is not like other evidence, as has been described, such as lab reports, crime scene photos, fingerprint evidence that's typical in other criminal cases. It is evidence that is very sensitive in nature. You've heard some of that described to you before today, and therefore it must be treated differently. This body has recognized that by continuously providing statutory protections for the forensic interview, not unlike evidence in child pornography cases and the like. The legislature expressly acknowledged and affirmed this as recent as 2013 with the passage of the Michael Morton Act, which made sweeping reforms to criminal discovery. I was a prosecutor, at that time, and was fortunate enough to be a part of some of those negotiations of that bill that session. In hammering out the bill's language, there was specific consideration of the CAC forensic interview. Under Michael Morton, the state is deemed to comply with discovery by providing the defense reasonable access to view the recording and is not required to provide a physical copy, as is the case with most other evidence under open file discovery. It is important to note that this has withstood the test of Texas courts, as there have been no sustained cases of due process violations or no sustained claims of ineffective assistance of counsel for the defendant not being provided a physical copy of the forensic interview. We have engaged with Representative Moody and his staff over the years with the different iterations of this bill, and I always appreciate him and his staff. But this is just one of those that we have to agree to disagree, unfortunately. I know that they have included language to attach criminal consequences to a defense attorney who recklessly releases a recording. And while this appears to give some teeth to the bill, I think it will be honestly largely unenforceable and very difficult for a prosecutor to prove. Additionally, the committee substitute codifies judicial discretion to release the recording, along with permissive language to allow protective order language to attach to that release. These are both already options for Texas judges, and judges are already releasing under these provisions currently. I mean, I would at least like to see the protective order language in the committee substitute be mandatory, but the scary reality is that we know what happens when these recordings land in the wrong hands. We see these forensic interviews, when this happens, posted online, posted on YouTube, posted on social media, and at that point, the graphic details of that child's traumatic abuse is out there for public consumption and the damage is done. So I ask that as you consider this bill, that you please ask yourself if there is really any compelling public policy reason for this bill. Does a defense attorney's convenience of scheduling an appointment and observing this video in a secure location at the DA's office outweigh the integrity of these very sensitive forensic interviews? But more importantly, does that defense attorney's convenience outweigh the safety and security and confidentiality of children who are disclosing abuse in these forensic interviews in this state? I think you know the answer to this, and that is why I ask you to vote no to HB 908.
Thank you, Mr. Wood. Members, do we have any questions? Vice Chair Cook.
Are you aware of any instances where this type of information is already online or anything like that? I mean, or is that just a concern that you have?
Yes, Representative Cook, great question. Thank you. Unfortunately, it is reality. We do see those circumstances. In fact, as recent, I won't get into the facts of that, but due to the sensitivity of it, as recent in the Dallas-Fort Worth area in the last 6 months to a year, there was 2 forensic interview recordings of 2 siblings that were posted on YouTube. We as an organization tried to help our center there locally and address that. Of course, then you get into contacting YouTube Legal to try to get said forensic interviews taken down, and that in and of itself is a nightmare of a process. But yes, we do encounter this. I don't think that most defense attorneys are doing this. I can't even say that was not even a case that a defense attorney would have been able to be held culpable under this statute or under what's proposed here. But the damage is when it's out there, we can't unring that bell, and we do experience that.
Obviously, without disclosing any type of identity, I mean, how did it become available to be posted on the internet?
We do not know that. We tried to do our due diligence to determine that. It was multiple forensic interview recordings that were posted.
Okay, all right, thank you.
Thank you. Any other questions, members? Thank you so much, Mr. Wood.
Thank you all.
Chair calls Stephen Brand. Thank you for being here today.
Yeah, thank you. Good. It's an afternoon, evening. I don't know. I've been here a while. My name is Steve Brand. I'm speaking on behalf of the bill, for the bill. And I'm speaking on behalf of the Texas Criminal Defense Lawyers Association and also as a private citizen. I've been practicing law. I'm licensed in the states of New York and Texas. I've been practicing in Texas since 2004. I've been a JAG attorney with the United States Air Force, prosecuting and then later defending with them. And I was a chief prosecutor with, as an assistant district attorney with the Travis County DA's office, and been private now since about 2014. I'm speaking on behalf of the bill because...
For the bill?
Yes, for the bill.
Okay, thank you.
Because we still have the presumption of innocence in Texas. Somebody is presumed innocent when they're arrested. And I think a lot of that's lost. You know, I've been sitting here through a lot of these different bills. And one of the things that gets lost is, because I've been working in the system so long, is that unfortunately a lot of judges see the same thing day in and day out. A lot of prosecutors see the same thing day in and day out. A lot of law enforcement see the same thing day in and day out. And it's this unconscious jadedness, for lack of a better term, that they get. So when it was talked about earlier that, you know, the defense system is overloaded, well, we'll just give 600 appointments to somebody. It's because people are like, well, look, here's the thing. Give them enough constitutional guarantees that you feel good that they got some fairness, but in the end, we think they're guilty. Spilling over to here, I mean, look, I know there's people from child advocacy. I get that. Obviously, people want to protect the children. It's the popular thing to do, right? I don't think anybody doesn't want to protect children, especially if you have children. We also know that often that there are times when children don't tell the truth, okay? You know, this is a popular thing to rail against until it's unpopular to rail against it. And I bring up the Greg Kelly case, which I think had the Netflix special on it, where people really believed, oh, well, this kid can't be telling the truth because Greg Kelly was a football player who's at a high school in Leander, and therefore we can't go with that. But here's the thing. All we want is fairness within the system. I'm a criminal defense attorney. I shouldn't have to make the trip of an hour, depending upon where it is, 2 hours, to first get to the place to review something that is a tool of my trade. I have no interest in disseminating this information. I'm truly just looking to represent a client. It would be like a doctor and you saying, well, instead of you having your tools in your doctor's office, you have to go to the hospital where you have privileges, but that's where you have to go about your craft. It's just not tenable. And here's the thing, we have no interest in disseminating this stuff any more than prosecutors do. The only difference between us as defense attorney and prosecutors and government officials is that they took an oath and they have a badge. That's the only difference. You know, it would be like a gynecologist. A gynecologist doesn't have a particular interest in vaginas for his own personal pleasure. It's because he's doing a craft and he's diagnosing individuals. That's where we come in. There's no particular street, other than creating this clamor about this, there's no particular street value in a child advocacy center video. Nobody wants it, a transcript of that, a transcript of a kid saying certain things, you know, which normally they uncover within a 10-minute span. The rest of it is rapport building and other things. It's a scare tactic to prevent fairness. There's nothing we're going to do with it. In fact, I would go farther than Representative Moody. I think he's throwing a bone to say that we could get a state jail felony if we release this information. That should be two-sided. The government should have a state jail felony if they release the information equally. It shouldn't just apply to us. I have no problem with it, not releasing it to anybody. Just trying to do my craft and help a client. The difference between this and child pornography on its face is contraband. You can't possess it in the state, it's a crime. Can't possess it with the feds, it's a crime. Not so for a child advocacy center video. Just like we get videos of adults who are explaining this stuff, it's the same thing for us. We're just looking to parse out the statement and see where we could cross-examine on behalf of our client. And if we truly are in a system where we're not going to give lip service to it during a jury trial, when they're giving jury instructions and saying that, hey, the accused in this case is presumed innocent, and the presumption of innocence alone is enough to acquit the defendant, then under those circumstances, we should abide by that and give defense equal access to evidence. Thank you for that time.
Thank you very much. Thank you. Members, do you have any questions for Mr. Brand? Yeah.
So as far as reasons why you're opposed, and obviously you just get a lot of testimony here, but I heard you talk about it's inconvenient for you to drive an hour or two. Is that correct? I mean, that's part of the reason you're against this bill?
Part of it. I mean, it's that sometimes I wake up in the middle of the night and I want to say, oh, hey, let me pop that into my computer. I just remembered something that, did this child really say this? And I have it at my fingertips and I could say, okay, I'll go do that, versus not having access to that evidence.
So have you actually gone and done, you know, I guess written a transcript or anything like that? Not a transcript, but have you taken notes from a video that you've watched in this circumstance?
I've taken extensive notes, but you have to kind of toe the line, you know, I mean, within the spirit of it, to how many notes can I really take? And we just had one case in June where my co-counsel had to go out there, I can't tell you how many times, to try to transcribe as best as possible with gaps the interview so we could use it later for cross-examination. It's just not the same. It's not the same of having it on your VLC media player or Windows media player and just saying, let me rewind that again, instead of having to, what we normally have to do, make an appointment with the DA's office, go out there, maybe I can't get one today, maybe it needs to be tomorrow, maybe the next day. I mean, we're not talking about weeks, but we're talking about sometimes days. And then say, okay, did I remember what I was just thinking about here? Yeah, I want to see this portion. And then you might go talk to your client about it. And then they raise another portion that you're like, okay, I need to go back again. I need to see this.
And have you had a circumstance where the actual video has been used at trial?
I haven't, where it's actually been used at trial, but I have another colleague who was here, he couldn't stay, who, that was another issue that came up, was he needed the Child Advocacy Center video for impeachment, and he has to rely on the state to make sure that they bring it that day, that time, to make sure that's available to them. And of course, then when you're talking about impeachment, then you're talking about making sure you have the recording counts recorded on your notes properly, and you've done that in the time that you've had to continue to go over to the office and review it. So it definitely poses major problems for the trial of the case as well and for impeachment.
But have you found that there's equal access? I mean, at that point, a judge is probably making the call, not a prosecutor. Is that correct?
I think if you're in trial, yes. And you know, one of the issues is that's being developed with case law right now, and it's kind of undecided, is whether we could actually get a transcript of it. And it seems to be right now, if the judge kind of orders the transcript, you're okay. If it's that the defense is asking for it and the court is blessing it, it seems like there could be an appeal taken from that, and the law at that point is in a state of flux.
And the last thing I had was you had made a statement a while ago, and I don't know that I fully understood what you said. You said there's no street value to this type of video, and then you went on and talked about, you know, child pornography, and you were comparing the two. What were you trying to explain there?
I'm saying there's a market for child pornography. I mean, I've represented individuals who have had a market for child pornography, and it's dealt on file sharing sites and dark web and whatever. I've never heard of a market for Child Advocacy Center videos or transcripts of Child Advocacy Center videos where people are just reading about what a girl said in one particular circumstance. I've never heard of a market from that.
Well, I mean, that's audio, but what about video? I mean,
well, but the video is them just really meeting in a room. I mean, I could describe the whole thing. It's like they meet in a room.
But I guess what I'm saying, let's say if a 10-year-old child pulls her pants down and says, "This is where he touched me," and I don't know if that's...
Never seen that in my entire life. What it is a forensic interviewer who really is just somebody trained in asking open-ended questions to kids so they're not leading them into a particular circumstance.
Would you agree with me that if that type of video is out there, that certain precautionary matters should be taken into account?
Absolutely. Never seen that before. In all the CACs I've seen, it's just, you know, they might say, can you make a drawing? And we might get access to that drawing later. Usually that's the room and where people are situated. Sure. But it takes them a good 15, 20 minutes to rapport build. The whole CAC video is usually about an hour in length, maybe an hour and a half tops. And they might discuss it for about 10 to 20 minutes in the middle there. But no, I've never seen take pants down, anything like that. They might have an anatomical doll that, like anatomically correct doll, that they'll explain or point to on the body where something might have occurred, but not anything where you're looking at anything.
So from your perspective, is it the audio that's more important to you, like a transcript of an audio?
Yes, very much so.
Thank you.
Thank you.
So can we narrow that to make it only audio? Is that something? Okay. 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 Thank you. Thank you very much. Right. Chair calls Michelle Ochoa. Hope I pronounced it right. Yes, you did. Thank you for being here.
Michelle Ochoa for Texas Rio Grande Legal Aid, and I'm testifying on the bill. Good afternoon, ladies and gentlemen of the committee, Chairman. My name is Michelle Ochoa, and I'm a public defender with Texas Rio Grande Legal Aid. I thank you for the opportunity to share with you guys what my experience is regarding CAC videos in the counties that I practice in, and I do practice in a rural community. As a defense attorney, access to essential pieces of discovery is crucial for preparing a quality defense. However, the current law has several unnecessary and arbitrary hurdles, which prevent us from being able to do our job. At this current time, under the current statute, materials describing alleged abuse can only be viewed at the district attorney's office, including the CAC video. And basically what we want the committee to understand is that the CAC video is simply a recorded witness statement. It would be no different than a witness statement in a murder case or a hit and run or a drive-by shooting. While we understand the need to protect witness privacy, Article 3915 fails to afford those protections and instead has the unintended consequence of impeding the defense's ability to effectively represent their clients. It's important for you guys to understand that the CAC videos are often the biggest and sometimes the only piece of evidence in these types of cases. Therefore, it's imperative that the defense has, or the defense is given, protected access to this discovery. Under the current statute, the courts use the terms reasonably available or ample opportunity to deny production of these videos, unless there's an outright deprivation. This interpretation gives prosecutors complete power to control when, where, and even if the defense team is allowed to view the evidence. It's alarming that a prosecutor can take the CAC video home to their own residence and while working remotely, and there's no protections in place to prevent unauthorized disclosure to a child or a loved one within their home. On the other hand, the current code prevents a defense attorney from having their own investigator or paralegal view the CAC video with them. This restriction inherently prevents me from being able to do my job. The current statute is especially problematic when the defense has retained an expert who resides in a different location and needs to view the video. How is that done? I'm going to have my expert fly down from Dallas County to watch a video that we could resolve much easier if we're able to view it and have a copy of it. This disparity undermines the fairness of our criminal justice system and violates the fundamental principles of due process. I hope that the members of this committee see that the proposed legislation resolves the unintended consequences of the current statute. I thank you for your time, and I implore you to ask me questions.
Thank you very much. Members, do we have any questions for the witness?
Sure, if you want to floor out.
Yes, Representative Cook.
So, I guess some of the testimony you said there at the end, let's say, for example, if you were to receive a copy of a written transcript from the interview, do you think you should be able to show that to your client?
My client, not necessarily. I think a client needs to...
Yes or no? Like,
yes, no, not necessarily.
No, I mean, like, yes or no, do you think you should be able to show it to your client, or you should not? Not necessarily.
Yes, I should be able to show it to my client. Okay. My client's looking at life in prison on a lot of these cases. He or she should be able to know every piece of evidence and everything that is going to be presented in court. I think that's the only fair thing to do in our criminal justice system.
Do you think that presents any type of intimidation for a 10-year-old?
The 10-year-old has to testify in court, period, and has to do it in front of my client unless there's special exceptions to that statute.
If there's a trial. And how often is there a trial?
In these types of cases, again, because there's very little wiggle room with the duty to register and with severe punishments.
If you know, I mean.
Lots. All of mine go to trial.
Okay. So, I mean, throughout the state of Texas, I mean,
Yes.
So statutory rape cases, I mean, you think most cases go to trial?
Yes.
Well,
statutory rape, probably not, because that's different than a CAC, a child, aggravated sexual assault of a child, or indecency with a child. Those are going to trial all the time.
Okay. And so you don't have any hesitations in showing that, sitting down, should you be able to give a copy of that to your client?
Copy to them? Absolutely not. Okay. I think they need to know what the alleged victim is going to say. And I sit down and I talk with my client and go, this is what the witness is going to say. Mm-hmm. This is what the offer is. Are you ready to go to trial and have your stepdaughter say these things in front of you? This is what's going to happen. Are you emotionally ready? Is this how you want to proceed in this case? And I would lay it all out there for them.
And then do you have any distinction between video and audio?
I think both are important. I need the video. My expert needs to be able to look at that child, see how that child responds to questions, reacts to questions, how that child is able to hold up to see if they're able, because they're experts in suggestibility or parental alienation. I think our experts need to be able to view that. I personally, because I don't have that expertise in that, but the transcript is important as well. Because if I want to impeach the child and say, well, do you remember telling the CAC worker he touched you on your knee but not on your boobie? I then have to get that video, go back, cue it up. Well, I had to, get permission from the judge. Judge, may I have a recess while the jury's all waiting for me to put in the video to cue up the exact number. It was at 4 minutes and 5 seconds where you said knee, not boobie. But today you're saying boobie, not knee. That is critical information that has to be illustrated and put in front of the jury so they can decide if a child is credible or not, to decide if which way they're going to decide on a case.
So if a defense attorney, if the prosecution has a transcript at trial, I mean, I'm assuming you're getting a copy of that as well?
I'm not allowed to take, I've tried to get a court reporter to go and transcribe it so I can have a working copy of it. I can't even do that.
No, what I'm asking you is if the state has a written transcript, you're entitled to that transcript, correct?
They'd probably consider it work product and not give it to me.
Okay. All right. Thank you.
Any other questions?
Members, do you have any questions? No,
Thank
so much
you
for testifying. Okay. Is there anyone else who wishes to testify on, for, or against HB 908? If not, the chair recognizes Chairman Moody to close on his bill.
Thank you. And members, I appreciate you taking the time to delve into this. As I said before, this is a sensitive topic. I've been having this conversation for quite some time. I do want to address a couple of the concerns, and you know, maybe this is a space where we just have to agree to disagree. But I have also been around here since Michael Morton, and so I want to first talk about, though, the idea of a chilling effect on child witnesses. That is simply not a real concern. Children do not ask the question if a defense attorney is going to get a copy of this and then clam up and not talk about things. That's not how these interviews work in practice. So to say that there's some sort of chilling effect because of this bill being, if this bill became law, on future ability to gather this evidence, that is just not a real concern, because that's not how these things are conducted. And that's not how children act. And so let's be very clear about that. And as someone who's been a prosecutor and a defense attorney, I will also be very clear with you. Disturbing, horrific things are talked about, demonstrated, as you heard here. Don't allow that, because what you'll do is you'll allow that description somehow to bleed into, well, we want, we're going to impute some nefarious motives on part of defense counsel, because they happen to be representing someone who is alleged to have done horrific things. Right? You have to be able to set the facts aside from the procedural. And that is difficult. I'm not here to tell you that's an easy thing to divide in your mind, but those are the things you have to do when we're touching on very sensitive issues of fairness in discovery. And back in Michael Morton, in fact, all the evidence back before that was treated very much like this. In fact, in some jurisdictions, a prosecutor will hold on to the file, and your defense attorney will, well, why don't you tell me what do you want to know? I'll tell you what's in here. And there are people in 2013 that objected to evidence being disclosed under the Michael Morton Act. They had the same fears that you heard here today. Well, it's going to be disseminated. It's going to be misused. It's going to, the sky is going to fall. Those are the opponents of that reform back in 2013. None of those things has been borne out in reality since then. And so the same arguments I heard 10 years ago when we're talking about discovery and fairness in discovery are being made here today. And I implore you to think about this issue. This is something that I will venture to say we won't solve this session, but it is a conversation we need to continue to have, because the issue of fairness in discovery is critical in making sure that we address convicting innocent folks. That is the crux of the matter. If people have the ability to understand what the evidence is and what's available, then we're going to have less innocent folks convicted of crimes. And that is a noble pursuit. It is not easy, and you're going to touch on some topics that make you feel very uncomfortable, but it's important because the principles of justice override all of it. I'm happy to answer any questions. And I know there was a comment about audio versus video. We can have those discussions too. Like I said, this has been a multi-session conversation. My guess is it might go for a few more. So I'm happy to have those conversations whenever you all see fit. If not, I close.
Thank you, Chair Moody. Members who have any questions?
Just one comment. I guess I would just ask respectfully, Chairman Moody, for you to consider, as far as chilling effect. I mean, as I've admitted several times last session, again this session, I'm not practicing the criminal law world, but I do practice in family law quite a bit, and so there's statutes where a child can have the right to come in and talk to a judge, and right now I think the age is 12, went down to 10, moved back up to 12. But so if mom says, hey, I want Sally to come in and tell the judge what his or her preferences is with regard to who she wants to live with, then there's a question, two questions. One is are the parents going to be in there to listen to the testimony? And two, is it going to be transcribed? And so from my experience, I mean, those two things do make a major difference. And I've never been a CPS investigator or a CAC investigator either, but I would think if I told the child, hey, your dad or your uncle or your cousin or whoever it is not going to see this video or not going to see this transcript or something of that sort, that would cause the child to have more faith or confidence in giving the truth. And so, I mean, I don't know if that's what you mean by not having a chilling effect, but I do think whether or not the child knows that the video or the audio, again, I don't know if the distinction makes sense or not, but if the child knows that knows it's going to be exchanged with dad's attorney or uncle's attorney or whatever, I do think that would impact how comfortable the child is in giving testimony.
I understand. I understand that. I just don't. I do not. That is not the way these interviews are conducted. Okay. They are open. They are open, and I have viewed these in a handful of cases. Not how they're conducted. That's not really the aim of them, right? And so we want to ask and get to whatever get child comfortable in a place to be able to describe any and all things, so that you can get all that out there to be able to preserve that for the record later. I don't believe a child is in that circumstance. First of all, I don't think that this would be part of that conversation. Interjecting that into this conversation would I think would be counter to the goal of the interview.
Well, I mean, I guess the example I would, and it's not exact same, but like in a mediation, what happens in a mediation is confidential. Mm-hmm. And so I know a mediator comes in and says, tells this party, I can't tell you what the other party said, but the fact that you're telling me and the other party's telling me something, I'll know whether or not there's overlap. And so people do, feel more confident and more comfortable in negotiating in a mediation because of that commitment that what I share is not necessarily going to be shared with the other party. And so, I know it's not a mediation when they do an interview, but I think that the same premise holds true that, depending on who's going to receive this information does impact how much or how little a child of, say, 10 years of age may or may not give, how much testimony they're going to give. So,
I mean, the concept of what an attorney even does is probably not, it's probably something a child wouldn't even appreciate in these cases. So I get what you're saying. I understand that. I do think in reality it would not create it. That is my opinion.
Maybe because of the fact that we are already giving access to that recording to the defense attorneys, so they're already getting it right now. This would not change anything, just the procedural way of allowing them to get a copy of that, even though they can see it themselves in the possession of the prosecutor, right?
But they're not getting a copy of it currently.
Right, they're not getting a copy of it, but they're at least able to see it. So we're telling probably the same thing to the child right now, that if they ask this question, that yes, they will be able to see that recording. The attorney of the defense will be able to see that recording right now. So it's not changing. If this bill does pass, it's not changing the fact that you're not saying that no, now they don't have a copy, or they did not have a copy before, but now they're going to be able to see it.
I just know there's a big difference. Like, again, most of my experience is family law related, so a comparable is a social study.
In which I have zero.
Yeah.
I will defer to you, sir.
And I don't mean to mix the two, but like in a family law situation, at least in Tarrant County, we cannot provide a copy of the social study to my client. I can review it like what was discussed earlier. I can talk about it and talk about what the contents are, but I can't give my client a copy of that. And so that's what I mean by.
I guess in mediation, there's confidentiality period. You cannot even disclose it. Here, you're already disclosing the video in close confine. That's what I'm saying. So it's not changing the fact that it is not confidential, basically. The process is confidential, where we're keeping it within closed doors, but the defendant attorney will still be able to see all the recording and see it physically. That's the only. There's a breach of confidentiality if there was.
I guess what I'm saying, it's the accused party that I'm talking about, not the attorney for the accused party.
Oh, okay, yeah, that's true. Yeah, they're not able to see.
That was a great discussion. Thank you. This is going to better inform the way that I work on this legislation. So thank you.
Thank you, Chairman Moody. All right. The committee substitute is withdrawn. Is there any objection to HB 908 being left pending? Hearing none, HB 908 is left pending. Thank you very much. Members, that concludes today's agenda. Is there any other further business for the committee to address? If not, the chair moves to adjourn. Is there an objection? Hearing none, the committee stands adjourned at 3:48 p.m., subject to the call of the chair. Thank you.
You need to tell Harrison you got